heart full of broken bones, and what was I thinking? I can taste the air as it's running down my tongue. I can taste the air as it's spinning up my lungs. I wanna feel this fire stand my chest. Smoke keeps spinning up my head. Just wanna just breathe. Just breathe. I can taste the air.
Yes, indeed. I can taste the air. So could you when you breathe. And when you breathe freely, what do you taste in the air? I taste a lot of shit. That's what's going on in this country, and that's what makes me mad. Okay, but again, you know, we have a guest on maybe who has ideas that could turn this around for we the people. Because I don't think, you know, I think he respects his free speech and the efforts he does. So I believe we have Mr. Jorissen on, or is it okay to call you James, sir?
It's okay to call me James.
All right. Hey, James, thank you very much for coming on the show. I got to tell you, you know, everything going on in this country makes me so mad. Now, I read a basic bio for you. Is there more to you that you would like to say, more on who you are and what you're about? And I apologize for that. I only had what I had to work with.
Well, yeah, basically, first of all, I'm a pastor also.
All right.
And
light of God.
Okay, so you have to square this, Gary.
Okay, so basically, I believe that in the beginning, the Word was with God and the Word was good. So when, even within our law system itself, God is within the system.
That's how it was able to be created based on scriptural concepts, correct, sir? The Constitution.
Yeah, you have the Constitution. You have exclusive equity, which is one side of the court, and then you have at law or Roman equity on the other side of the court. So, and there's also common law. So there's ways to reduce the ability of a judge to do something. One is called the laws of the case. If you put in, I'm just going to say it's like 24 cases. It could be more than that, or 12. I forget how many it is, but there's a list of cases that takes away the court's discretion that they use. Right. Francis asked me a question earlier about I told him about a constitutional question, right?
Okay.
And in Florida, it's under Rule 1.007 or 1.071 point. Constitutional challenge to state statutes and county or municipalities, charters, ordinances, or franchises noticed by party. Guess what a franchise is?
A business?
A franchise is a subdivision of the state corporations. The state, like the state of Nevada or the state of Florida. The franchises are judgeships. The judges have the judges' court, or the judgeships underneath the court system, are franchises issued by the state government. So in Florida, where how you challenge it, you have to file a notice of constitutional questions stating the questions and identify the document that raises it, and then you have to give the pleadings to. So first of all, if it's a constitutional question of the state constitution, you have to notify the Attorney General of the state. If it's a constitutional question regarding the Constitution of the United States on the parchment, then you notify the Attorney General of the United States of America. Okay.
Okay.
So you send your constitutional questions to them first, certified mail return receipt, and then you get the little green cards back. And you take the green cards, and then you file your notice of constitutional question in the court case that you have.
Okay.
Now I had three criminal traffic cases. Okay, and there's three different jurisdictions. One was in Colorado,
where I
One
am.
was in California, and I think the other one was in New Jersey or somewhere on the East Coast. Okay.
Mm-hmm.
So we put the constitutional question in. Here's the question. It says, notice of constitutional question. It says, I blank come. Plaintiff timely filed his affirmative defenses as follows. Notice the constitutional question. Whereas the third section of the sixth article of the Constitution of the United States of America mandates that the senators and representatives before mentioned and the members of the several states, legislatures, and all executive officers and judicial officers, both of the United States and of the several states, shall be bound by an oath and affirmations supported this Constitution this Constitution, but no religious test shall ever be required as qualifications of the office or public trust under the United States, whereas the act in regulation, time, manner, and administering certain oaths is incorporated into statutes at large, 1 Stat 23, which was the first law passed by the Congress and ratified, the ratification of the Constitution of the United States, in which it mandates, and it goes back through 1 Stat 23. I hereby do solemnly swear to affirm that will support the Constitution of the United States. Right. So that's the public one, and then you go down here. It says, whereas in 1 United States Code, Section 112, statutes at large contain admissible in evidence as mandated that the United States statutes at large shall be legal evidence of law in all courts of the United States and the several states and the territories of the United States.
Which to me just sounds like they have to abide by the laws and rules of the Constitution. So far, what I'm hearing, in the least, right, sir?
Well, it's basically, this is about their oath.
Extremely powerful way to form a procedure. Extremely.
Here's the first question. Are the laws the defendant is accused of offending enacted by constitutionally qualified persons? Second question. Are the courts, judicial and executive officers constitutionally qualified to prosecute and adjudicate the laws of the state of Colorado? Okay. Mm-hmm. Question 3. The prosecutor is a member of the bar and a judicial officer under the judicial branch, and at the same time is a prosecutor under the executive branch of government. Is this a violation of the Separation of Powers Act? Question number 4.
Sounds like a good question.
Is members of the bar a private organization or members of the judicial branch?
Oh, the blood bar cult. Isn't that interesting? That's
question 5. The prosecutor is a member of the bar. The judge is a member of the bar. Does this private membership deprive the defendant of a right for an impartial tribunal and an impartial judge? Now we go to the crux of the case, which is the number 6 question. Mm-hmm. Is it constitutionally required for the lawyers acting on the defense, prosecution, or adjudicating in a criminal case or civil case, proceeding in this case of the United States, to execute their oath of office as article an act to regulate time and manner and place and certain, goes through that, and then the state executes the judicial officers for them to have a record or certificate of proof before the proceeding is executed due to their respective office. Right? And then you have this where it goes to the Attorney General of the state of Colorado, and it went to the United States Attorney General. Right, we sent it, got back, boom, put it in the case. Right,
you got the card.
Got the cards back, attached the cards as exhibits with it, and filed it into the criminal traffic case.
Okay.
It took 7 hearings. Each hearing was called request of counsel. Now I have to back up because I know neither one of you have probably ever heard of this. You've heard of Alan Dershowitz, right?
Of course.
Yes.
Alan Dershowitz wrote a report called the Testaline Brief, and the Testaline Brief was put in.
Test line or Tessa line?
Testaline, lying.
Okay.
That's the term that the cops and prosecutors use when they lie.
Oh.
So the Testaline Brief said because in gist,
I didn't know that.
you put it into a traffic case
Okay.
and the police officers disappear. They will not call. They will not call him to the stand. They will not speak.
So how could that stick then? Is that like kind of where that's going? Like the right to face the accuser type of thing, or am I way out left field?
No, you're understanding they can't be a witness.
They cannot be a witness.
No, because you just stated under penalties of perjury you took, and guess where it not only is his Testaline Brief put into the case, but his testimony before the Judiciary Committee on Perjury is on the case. In the case.
So they know he will not have it. He's not
as
going to be
exhibit. Yeah, as Exhibit A, and then as Exhibit B, you put in the Feretta case of California.
Mhm.
The Feretta case, what happened is he was doing his thing. Judge said, "Okay, we got this guy," and he goes, "Your Honor, I have a right to dire the counsel, so I know whether I can accept him as not as being my counsel." And so the judge goes, "Okay." So then he asked him, "Where'd you go to law school? Where'd you do this? Have you ever been convicted of a crime? Have you ever been pulled over for a DUI? Any of that?" No. Okay. He goes, "Your Honor," and I said, "What's the defense? Right now, you said you just practiced law for 20 years. You should be able to tell me what the defense is against this charge." Well, no, I have to look it up.
You tell us. I got a point here. You just brought it. Now, he tried to bring up things, as a loophole to screw you out of your rights to adhere to the Constitution that he's also obliged to do, or am I off in left field again? I want to just be clear on that because that's what I'm hearing.
Basically what it is a judge has to have an oath of office. Okay?
Right.
The prosecutor has to have an oath of office.
Right. But if he's saying, did you commit a crime? What difference does it make?
He's asking, the defendant is asking the attorney that the judge just appointed to him as his counsel.
Okay, I got it. The other way around. All right, I get it. I'm sorry.
Okay. So he
Not
said,
the other
Your
way
Honor,
around. The
so
judge assigned an attorney to the defendant, Gary.
Yep. And so what happened is he says, "Your Honor, obviously this attorney is incompetent because he cannot tell me what the defense is."
Oh, wow.
So Feretta went through it's either 6 or 7 attorneys while he was doing this on the stand, and each one of them was disqualified. So then a guy walked into the courtroom, a fancy attorney in LA,
right,
or walks in, and he said, "I'm done with this bullshit." And the judge goes, "That's your attorney." And he goes, "Well, I don't like that guy, Your Honor." "No, that's your attorney, and you're stuck with him. Have a good day."
That's not very wrong, obviously.
So now you're going to hear what happened. So the guy hated him, and the other guy hated him, and he didn't like him, didn't want to do the defense that the guy wanted to use. And the guy lost, and Feretta appealed. And Feretta appealed, said he had the right to assistance of counsel and to do the argument that he wanted to present, not what the attorney wanted to present.
Boy, do I like that.
And so the Feretta case has multiple ramifications, but one is that you can represent yourself. The second is your due process rights are violated when you is also under that same case. So it took him, I think, now don't quote me on this, but somewhere about 6-7 years.
Wow.
And he got it appealed. And he lost in the district court, lost in the appellate court where he was at, lost in the second appellate hearing, went to the Supreme Court of California. He lost there, went to the Supreme Court of the United States, and he won. The case was overturned. And
Can
he
I
was
interrupt?
Yeah.
Why would the United States Supreme Court pick that case? Because you know that the Supreme Court gets 7,000 requests for hearing at the Supreme Court, and only a few hundred get accepted. How did he break the chain?
Okay, I'm not going to say the name of the state. We talked privately. I told you the name of the state, but I'm not going to say the name of the state that I'm going to say that it was, we'll say Michigan. Okay.
Mm-hmm.
There was a certiorari just written for Michigan Supreme Court and they accepted it. I'm just going to say this Supreme Court accepted a hearing that was denied all the way down and all the way up.
I don't understand why not mention. I don't know, so forgive my ignorance, but I think that's a good question. Why not mention it? Are you afraid of something? Is it unconstitutional?
There could be ramifications to me. That's why I'm not going to specify exactly which state.
What do you mean ramifications? So we understand.
Because nobody knows that I helped write it.
Oh. Well, that's a good win for you, obviously.
So what I'm trying to say is that
all Americans, whatever good what you're talking about is.
So basically, what it is the reason why the Supreme Court heard this particular case, is because there's a 3 strikes law in California.
Right.
Okay, and the 3 strikes law, if it's your 3rd felony, you're put in prison for life. Doesn't matter what the felony is. You get the 3rd felony, you could shoplift over $1,000. It's a felony, you'd be in prison for life. There is no discretion on it. So the Supreme Court heard this case because it had he argued the right that he had the right to represent himself. The judge took away his right to represent himself.
Right, because he said, no, you're going to go with this guy, whether you like it or not.
Right. And so basically, the ramifications of that was on the Ferretta case is on self-representation, picking a counsel of your choice, doesn't have to be a bar member.
Oh.
Or not having a lawyer.
No, you can are not having a lawyer, and it's also due process rights reflect in the 6th Amendment. And then the 3rd reason was a right to have an attorney assist you in the defense that you want to provide, not the defense that he wants to provide.
That's great. So that's the Ferretta case. Can you spell that Ferretta? Could you spell Ferretta?
I mess it up all the time. You're going to have it in your inbox, Francis.
Okay.
I'm going to give you a copy of the Exhibit A for the traffic lawsuits.
Mm-hmm. I would do that too for the archive page, sir, and of course any websites or anything else you would like me to put on for the archive page.
Yeah, so
I appreciate that. And you say you're a pastor, right? That means you're a pastor of a church?
I'm a pastor of a church association with another pastor who's taking the churches back to Christ.
Thanking. Oh, do you have a website or info I could also put on the?
I can get information for the church organization to you for that.
And I'll let my first impression fool you, sir. I am, saved by the blood and faith, and I know when I'm born again, man, I will not do the things that I know I should not do, but that I do. You know what I mean? And I look forward to that time. And so anything that I could help with there, just like, again, anything I could get on the MENA, you know what I'm saying?
Right. So here's the difference in churches. You go back to when they issued the 501c3s, when Johnson signed it into law. Mm-hmm. It was to strip the churches of their pulpit. And to a church deduction, you're only allowed to deduct 50% of a church deduction to a 501c3, right?
Huh.
But nobody really understood where the other 50% went.
That's a good question.
Right? Well, it went to, supposedly, it went to help Planned Parenthood and 5 other organizations that Johnson wanted to fund.
Oh, King Holy Be Jesus will be very happy at that.
right?
Yeah.
So a 508c1a is the exception. See, anytime the devil does something, he has to give the Christ exemption. There has to be an exemption for Christ, right? When he does one thing, he has to say what the exemption is that frees you from that bondage, because he can't lie. Like Christ, the word has to be both. So he uses the word against the people, but yet he has to live by the word because he was created by the word.
That makes sense.
So
it's not. It's madness. It's crazy. That's why it's nuts.
So it's on one side you have A and B. That's why when you read a statute, forward, it tells you one thing. You read the statute backwards, it tells you what you need.
Holy crap! I never thought of it.
I don't
Is
really. Can you explain that in detail?
Okay, you read a statute
Yeah.
from the beginning,
Right.
right to left.
Yeah.
Then you read it left to right to get the meaning of the statute.
Well, how can you do that? It's not going to make sense.
It does.
Can you give an example, sir?
Let's see.
That's very interesting. That's a good way of reading between the lines.
Well, see, I also have I have multiple gifts, but one gift is I had the ability to read taken away again, so I had to learn to read again.
Wow.
When I was 32, so I was reading case law.
You wait. You knew how to read. Obviously, you were great. Something happened. And then you had to learn to read again.
Yeah, I was in a car accident and I lost the ability to read, write, and even move a pencil with my hand.
Listening to you, sir, one would never have thought. God bless.
Well, the verbal communications is off the chart for me on when they tested me after the accident, verbal communication was in the 99th percentile, along with anything to do with financial and credit, because all the connective tissue was in that area.
Oh.
So the first time I didn't learn to read till I was 23. Wow. I'll give the example. I was in a grocery store. I worked for a grocery store for many years. Started when I was 14, and it's relaxing to me. I like it. It's fun, right? So they changed the labels on a soup can, and I went to go get a price check, and I couldn't find the label. And then the manager came up and came down to the aisle and where I was looking for it, and he looks at me and says, "You can't read." And I went like, "I can read a little." He goes, "You can't find it because they changed the label." And I said, "I'm sorry, sir, I can't find it now." He goes, "Where's this at?" And I told him it's on aisle 1, 3/4 way down the shelf, 3 shelves up, and halfway down the aisle.
That's what kept the job.
And he goes, you memorized the whole store." I says, "Yeah, I memorized everything in the store." He goes, "We're fixing this." And so I went to the college, and the college threw down 8 different ways of learning to read, and none of them made sense. See, they threw the 9th one down. They go, "Does this make sense?" Huh. And I went like, "That one makes sense." He goes, "Well, if it was, we're going to have to come up with a 10th. I go, "What do you mean?" He says, "Each one of these was designed because a specific student had a different way of learning."
That's awesome for humanity.
And so
trove of knowledge.
So then I learned to read then. That was like, I think 22 or 23. And then, and then I made reading became fun. And so I started just reading stuff and had fun. At 32, I got in the car accident. I lost all memory from 32 years back. I didn't know who my parents were, didn't know who my kids were, didn't know who my wife was, didn't know who my friends were. Had total amnesia on that. And so at 32, I basically started again. And that's when roughly around 2001, I filed the lawsuit against the TransUnion. Well, it was Walmart Stores Incorporated, TransUnion, Exo Collecto, and AAA Collections. And AAA Collections are the scum of the earth. That's just what I'm going to say. and I won. They settled out of court with me. So
After you learn how to read again?
Yeah. That's
How
why I was
long did
reading case.
you learn to read again from that point? I mean, that's an important factor because, you know.
The accident was 98.
Okay.
The lawsuit was 2001. So basically, roughly 2 years.
All right, so well, that ain't really bad considering it's not like years and like going through the patterns and everything again. Well, are you able to write scripts, sir, or did you remember? I'm sure you did when you were younger. Did that go, and was that able to come back also? You know, script writing.
No, that took 9 years to write with the hand.
Wow. Because of the accident.
Yep.
Wow. God bless you, sir. God bless you. Know, they say there's no miracles, but there are. But okay.
So that's just a rough.
You didn't have to get personal. You know, we appreciate it. You know, it just shows us more of who you are and doing this. I respect that and thank you.
So basically, what it was is I love law, and I love law because I see God in law. Okay, that's what I see. And every time I write something, I pray about it. I have God and the Holy Ghost help me write it.
Okay. Yes.
So that's where you get so to put this in, you put in the exhibit on the criminal case. You put in the exhibit. You put in the Feretta case is an exhibit. Rule 1.5 is an exhibit. The Federal Rules of Civil Procedure, and then the testimony brief and his testimony before the judiciary. Every time this has gone into a traffic case, the cases get dismissed. If it's criminal, it takes a little longer. It took 7 months in Colorado. So they had 7 hearings of appointment of counsel. And he goes, well, we're going to appoint counsel. He says, no, I don't need counsel appointed. He says, the Feretta case allows me to represent myself, and there's a due process violation. If there's a due process violation, like lack of subject matter jurisdiction, Your Honor, that's how you proceed. We have to proceed with this, and you have to. I can't even enter a plea, Your Honor, until we talk about the constitutional question, because the constitutional question comes first before any plea gets entered.
So the defendant is saying that to the judge, right?
Right.
So these judges must be so pissed at this guy.
So the judge goes, okay, I'm going to let you go talk to the DA. And he went to talk to the DA. And after I talk about this, I'm going to tell you about the being as dumb as a box of rocks. Okay.
Like many of us thought when we go to court. That's why we need lawyers, they say, right?
Right. So basically, the judge had him talk to the prosecutor. The prosecutor offered him a plea of 3 months in jail. He said no. And so he comes back. Then they set a hearing another. So they have 7. They have like 5, we'll say 5 notice to appoint counsel hearings, right? And then they had the status conference came. All right. Now, during this time period, he had like 4 or 5. This one had 4 or 5 prosecutors. So the judge goes, before we start trial, ma'am, is there anything you want to start and say before we put this stuff down here? And she goes like, I don't know what to do, Your Honor. Oh, the hearing before this, he dismissed his first motion to dismiss on lack of subject matter jurisdiction, right? Because the judge said that the court has a right to hear the things under the Article 1, Section 4 of the Constitution, something like that. The Colorado has the right to do stuff, right? It has a right to have county courts, district courts, Supreme Court, all that. He's talking about the courts, right?
Right.
When he dismissed it, again, my friend goes, well, what do I do now? I says, well, we file a second motion to dismiss. And in the second motion to dismiss, he stated that the judge and the prosecuting attorney failed to provide their certificate of oath of office as provided by the statute. And then we go into I'm going to see if I can pull it up here.
I wonder, man. I'll just say that. Go ahead, sir.
So finally, the second one, and then we state in there. I'm gonna for just let's see. I'm gonna see if I can pull up Polly's case or the.
Okay, while you're doing that, do you have to ask for the oath, or did they have to automatically provide it?
They have to provide it. It says in the oath. It says right there in that statute that I read. Right. It
Yeah.
says that they're supposed to provide it immediately before they execute their duty.
Hardly
Before
any
they.
judges ever do that.
Well, you're notifying him. You notify the attorney general of both the federal and the state, right?
Gotcha.
So you notified him that this is your questions. Well, you haven't answered them, Your Honor, and you haven't provided it. So then in the second motion to dismiss, we say, hey, I'll just read it from Alex's. I'll just hit Alex and then go to second motion to dismiss here. See if it finds it. Where does it go? There we go. Or do I have it open here? Hang on. Let's see.
So I'm sure while you're doing that, you have an incredible testimony, especially being a pastor of churches and whatnot. So that's you have a website where people could see all that, or no?
No, the one website is it just promotes the one book, the 13 books, but
all right, well, links to anything and everything.
Yep.
So
I'll get that to you so you can do that when they rehear the podcast, that they can have a place to go.
Perfect.
But basically, here's what we said in the motion to dismiss, right? I think this is second. Okay, you can't. The motion to dismiss for lack of subject matter jurisdiction, 12B1. See Holloway versus Pagan River Dockside Food Workers, Inc. And then basically it says argument in regards to the court's inferior jurisdiction. If the record does not show upon its face the facts necessary to give jurisdiction, there will be presumed that did not have existed. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Murdoch versus Penn, 1934.
Wow.
Okay, and then you have jurisdiction of the court can be challenged at any stage of the proceeding, also may be challenged after conviction and after execution of a judgment by way of a writ of habeas corpus. Most people don't realize that a writ of habeas corpus can be used for subject matter jurisdiction reasons.
Now, what is that writ of habeas corpus for people that are saying, okay, what's habeas corpus?
Well, usually it's to produce the body. In this sense, is to challenge the corporate's jurisdiction under U.S. versus Anderson.
Okay.
U.S. versus Anderson, 60 F. Supplement SUPP. 649 D.C. Washington, 1945. That's the case link. And I sent the cases to Francis, and Francis can give them to you to make sure you guys have it. So I gave an example. I gave that one. So basically, it goes into construction of the statute. What a statute, plain meaning of the statute. We put it in there, all that stuff, good stuff. We put in affirmative defense number 4, section 4. Jurisdiction of Supreme Court and courts of appeals, appointment of judges to sit for disqualified justices or judges. The Supreme Court and the Court of Appeals have the appellate jurisdiction in civil cases arising in district courts and also on questions on law alone in all criminal cases in which the offense charge is within the original jurisdiction of the district court. The Supreme Court shall fix by rule the jurisdiction of a court of appeals or shall provide for a review with appropriate appeals decisions by the Court of Appeals. The Supreme Court and the Court of Appeals have power to issue writs of mandamus, certiorari, prohibition, quoranto, and habeas corpus, and also all writs necessary to properly and to complete exercise of their just jurisdiction. Each justice of the Supreme Court and the judges of the Court of Appeals may issue writs of habeas corpus to any part of the state upon penalties of perjury, or upon petition by and our belief of any persons held in actual custody in the state may make such writs returnable before the issue of justice or judge for the court which the justices or judges is a member of, or before the district court of the state of any jurisdiction. And the reason why I put that in the case is because that helps in the issuing of writs when you want to have it changed, when you have to appeal the court's decision.
There's a whole lot of them there to go by.
Yep. And then number one is the state. The state is a party of Colorado. The Supreme Court has original jurisdiction. The defendant moves this court. It's very important to say move this court. The defendant moves this court, places the court under the authority of the Supremacy and Equal Protection Clause of the United States Constitution, Article 4, Section 2. Citizens of each state have the right and all privileges of the immunities of the citizens of the several states, to include common law authorities of Haynes v. Kerner, Plotsky versus CIA, Anastasia versus United States, Henry pro se regarded attorneys. Regardless of the deficiency of their pleadings, pro se litigants are litigants. Defendants in pro se litigants are held to less stringent pleading standards, and the bar entitled to operate to submit evidence in support of their claim. In Plotsky, the court erred if the court dismisses the pro se litigants without instructions on how pleadings are deficient and how to repair the pleadings. Now here we go into this. The U.S. Supreme Court and other high courts certiorari providing that no license is necessary for the normal use of an automobile on the common ways. The right of a citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is mere privilege, which is a mere privilege, which may not be permitted or prohibited at will by common right, which he has under his right liberty in the pursuit of happiness. Under the Constitution, guarantee one may, therefore, under normal circumstances, travel at his inclination along the public highway or in places, public spaces, and while conducting himself in the ordinary decent manner, neither interfering with or nor disturbing another rights. He will be protected not only in his person, but in his safety of conduct.
So you made it a right and not a privilege.
The right to travel is a privilege.
What do you mean a privilege that could just be taken away from someone?
No. I'm sorry. I said that wrong. I thought
it's so.
It's not a privilege. It's a right.
Correct.
Right.
That's what I was saying.
That first case I read where it says that you cannot convert a privilege into a right and then tax it and pay a fee to it.
Exactly.
That's what the traffic tickets are taxes.
Mm-hmm.
Or sheets of tax and ladings.
Well, you could say court fees are that too. I mean, they've made,
This this list of public record constitutes 51 cases. 51 were obtained through Pacer and Google Scholar.
So what was this guy? What was this guy? I'm sorry, but what was this guy? He was like, oh, I don't have a license, but I have the right to travel. Was this like an issue like that?
No, he basically what happened was he had a medical episode. Doesn't know why it happened. And he ran into a fence and destroyed a fence, and they were going to they charged him with reckless driving.
Boy, that's going to happen a lot more now. Oh my gosh.
Felony reckless driving. Any ticket, right? What's a ticket start from?
The police.
Ticket starts from pulling you over, right?
Right.
Okay, when they pull you over and they stop, if you're either in a vehicle or if you're walking, If they impede the locomotion, they've trespassed on your liberty.
Really?
Yes.
Meaning they made you stop, but if you're already crashed, you're already stopped.
Right. But anyways, he went home, got a different vehicle, came back and was writing a note saying that he was going to pay for the damages. And that's when they arrested him. For 15.
And charge him of fleeing the scene, I bet, too.
Yes, they did. But anyways, okay, so anything dealing with traffic, it starts with traffic, right? Anything after traffic, the probable cause is traffic.
Right.
So it has to be a reason why you pulled him over or something happened.
Right. I was going to ask you that. Go ahead.
Okay. So I'm going on. So we list 51 cases here of the right to travel.
I was just talking about this a couple of weeks ago with a buddy of mine. I'm going to, if he's not listening, I'm going to definitely send him this archive. It's interesting.
So basically, you say here in above citation, American jurisprudence, and citations may be paraphrased. Defendant's answers to plaintiff's complaint as follows. Traffic misdemeanors and citation complaints. Defendant denies all allegations of said complaint. As all allegations denied, defendant demands strict proof, therefore, by the plaintiff. Affirmative sense. Failure to state a claim. Plaintiff has failed to state a claim upon which relief can be granted. Complaint in each cause of action therein fails to state a factual sufficiency to constitute a cause of action against the defendant for which the relief can be granted.
Right.
And then we state my favorite case is United States versus Lavasco. United States versus Lavasco is 431 U.S. 783, and then the Supreme Court statute is 97 S.CT.2044. Okay, so it says here, contrary to Movian's claim, has no legal standing to bring this complaint for basically whatever the damages they say. Money damages, open book, money left. 3, the complaint states on the basis of evidence produced, attorneys can't testify. Statements of counsel and oral or brief or arguments are not before the court. And the findings of a continuing investigation, which forms the foundation of the majority opinion, comes from statements of counsel made during the appellate process, as we have said, of other unsworn statements, which were not part of the record, and therefore could not be considered by the trial court. Manifestly, such statements cannot be properly considered by us in the disposition of a case. Statements of counsel and brief or oral arguments are not sufficient for a motion to dismiss or for a motion of summary judgment. Trenzi versus Pagliaro, and that's Trinsey versus Pagliaro, Pagliaro.
But that happens in courts day in and day out.
Yep. You have to place it in your complaints.
Yeah.
Because the pleading of the sovereign comes from the 4 corners of the complaint or 4 corners of his answer. A plaintiff under no possible view, however, for the findings of considering can they be held to constitute compliance with the statute, since they, now this is the best part, since they merely embody conflictive statements of counsels concerning the facts as they suppose them to be, and their appreciation of law, which they deem applicable. There being therefore no attempt. Say that again. Okay, being no attempt whatsoever for the statute, the ultimate fact by a consideration of which we would be able to conclude. Huh? Go ahead.
Gary, you're not coming through.
Yeah, I know. I got an issue on my end. Just go ahead. Keep going.
Okay. All right, and therefore, no attempt whether to state an ultimate fact by.
Keep going, James. Keep going,
Okay.
James.
I'm back. Yeah.
Okay.
The problem, Angel knows. I'm not going to get into it, but go ahead, sir. I'm
Okay.
following. Hopefully everyone else heard you clear, though.
Okay, let's not interrupt James. Go ahead, James.
Okay, therefore, no attempt whatsoever to state an ultimate fact by consideration of which would be able to conclude whether or not the judgment was warranted. Okay, that goes through all that stuff. Tells you everything in a criminal case, that it's their philosophy of how they view the law, not what the law actually means.
Wow, that's powerful. What about civil cases?
This is a civil case. This can be used in a civil case. It's the same thing.
I needed that said on the program. Okay.
Yep. And then here you go. And then we have Gonzalez versus I can't pronounce the other name, but it's a U.S. It'll be a 224 U.S.126. No instruction was asked, but as we have said, the judge told the jury that they were to regard only the evidence admitted by him and not statements of the counsel.
Huh.
And then you have Hoyt versus United States, which is HOLT. Likable. An action must be prosecuted in the real party in interest. The standing doctrine involves both constitutional limitations on the federal court jurisdiction and prudential limitations on its exercising of its exercise, how it exercises it. And that's Kalowski versus TESMER, which is 543 U.S.125.
Okay, could you explain that in detail? What is that? Could you put that in plain English?
If somebody is suing you and they're not suing you they're not the real party in interest, they're not the one that has the mortgage, the one that finalized the mortgage, they can't sue on behalf of them.
That's powerful with credit law.
Yeah, I'm going to go over the credit law in a second. You guys are going to be blown away. But anyways, this is just the defense, right? That's just the defense of why they failed to state a claim, because they don't have a witness. Who was a witness? The police officer. Excuse me. The police officer was a witness. The police officer was a prosecutor, and the police officer was a judge when he signed the ticket. They're signing the ticket away, right?
Ah.
But the ticket's a charge.
The ticket is a contract against the body. Against the body to produce.
Wow. Okay.
It's a contract to access the money and to, however, there's lots of things that happen when that. But anyways, beside the point. That part there, right? So then we get into the fun part. Second affirmative defense is violates the parole evidence rule. Defendant alleges that the complaint, including references to alleged agreements made outside the alleged written contract, violates the parole evidence rule. Lack of I can never pronounce this one. I'm sorry, guys. It's PRIVITY. Privity, I think.
Privity.
Yeah. Defendant claims lack of privity, as defendant has never entered into any contractual or debtor-creditor arrangement with the plaintiff. Doctrine of estoppel. Defendant alleges that the plaintiff's complaint and each cause of action therein is barred by the doctrine of estoppel, especially estoppel Perez. Rights of a citizen.
Powerful.
Rights of a citizen. The rights of a citizen to travel upon the public highways and transport his property thereon by horse-drawn carriage, wagon, automobile is not a mere privilege which may be permitted or prohibited, will be but a common right, which has under his right to life, liberty, and pursuit of happiness.
Now, unless there's like a vehicle, unless you're using it for commerce or business, or is that just in some states, or how does that work? I'm sorry.
Commerce and business, you're in business. You're doing commerce. Commerce is what they charge everybody for. Every citation is a commercial citation. There is no private citations for travel.
they're infringing on your rights of travel then by being a business under you.
Right. So anyway, so basically that's all of the rigmarole of the that's going through the public defenses, and then basically the last part here we just asked for simple little, hang on. We say conclusion, wherefore for these reasons defendant moves this court for an order to grant defendant's motion to dismiss. Defendant moves this court for an order granting a defendant's motion to dismiss. Blah, blah, blah. It's a verified complaint. He had to go through 7 hearings that lasted 7 months, basically.
Oh, I thought you said 7 years.
No, 7 months. No. These were quick. Okay. The gun case in California took 9 months. The gun case was he got pulled. He was in a car space. Okay, first of all, back up. Walked out of a strip club, walked across the street, saw a car with no lights on, driving down the street, went to his car, got in his car, turned the car on, started to back up, and the police car pulled him over in the parking space.
Huh.
Yeah, in this particular case, they were kind of stupid, and they still brought the officer to testify, and the officer lied on the body cam was used as proof to show that the police officer lied.
I was saying the car was moving and the guy never even got out of the parking space.
Yeah.
No, he said the car wasn't moving when the car did move. The car moved 2 feet. 2 feet. And he said the car didn't move. We just pulled him over and we asked him what he was doing here, and then we asked him if he had any drugs in the car or guns, and he said, yes, I have guns. And the guns were locked in a trunk, locked inside a case, inside a backpack, locked inside another case. So it's in 3 cases.
Right.
And so basically it took about 9 months for that one. It was dismissed, and the guns were told to be given back to him in California.
Wow, that's surprising.
The toughest state for guns.
Yep.
I wonder
So
if
what was interesting about that case before, they related the pursuit of happiness, which comes out of the Declaration of Independence, and they defined a right to travel out of that. That's extraordinary.
Well, see, your rights to practice law comes from the First Amendment.
Free speech.
Uh-huh. And so there are cases that say that you are allowed to practice law and it is a constitutional vocational right.
That's why they don't teach it to kids in schools and everything, because we were overthrown.
They don't teach the Constitution in law school, which they should. That has to change.
No,
they don't teach I mean, am I right?
No,
James?
They teach constitutional law. They just don't teach you how to. See, this statute tells you, like the California statute, right?
Yeah.
I'm going to read that statute. Florida statute rule 1.071. Right. It says constitutional challenge to a state statute, our county, our municipality, charter, ordinance, our franchise by notice by party. The party filing a pleading, written motion, or other document drawing into question the constitutionality of a state statute, our county, our municipal charter, ordinance, or franchise must promptly file a notice of constitutional question, state the question, and identify the document that raises it, and B, serve the notice and the pleadings, written motion of document drawn into the question of the constitutionality of the state statute, our county, our municipal charter, ordinance, franchise, our on the Attorney General or the state attorney of the judicial circuit in which the action is pending by either certified or registered mail. Serving the notice of the pleading, written motion, and document does not required joiner of the Attorney General are the state attorney as a party to the action. So you're informing him. You have to inform him that there's a problem. And that's how you institute how you're supposed to get your constitutional question answered, right? So every single case that was criminal that this case constitutional question went into, the cases were dismissed.
Wonder if we could do something like that, Frank, to get my money back, but let's not get into that now.
There's aspects to what he's saying that you can absolutely get action that you haven't been getting.
All right, let's talk about that later.
Yeah.
All right.
So
Well,
this gives you guys the idea of, and the viewers that are listening, an idea how powerful that constitutional question is.
It is.
Because it's been used in a foreclosure case in New York and it won.
wow.
And the judge, this is the funny part of the hearing. And then, okay, I won't say that. There's another hearing that happened after that one where another party that I know personally
In New York?
God, I don't know what state she's in.
Oh, all right, go ahead, sir.
I think this one was in New York also.
All right.
But I'm not sure. But my friend helped another friend. And so she filed the same thing and she's sitting in there with her friend in court, right?
Mm-hmm.
And this is what the judge does. He goes, Your Honor, I have this question. He goes, yeah, just about that question. Hang on just a second. Defense counsel or plaintiffs, don't worry. I'm taking a break. He says he sits there, he takes his robe off, sets it on the chair, right?
Which means he's not there. He's off the stand.
The judge has left the courtroom.
No, so the judge asked her to go with him. So she goes outside in the hallway, and she's talking with the judge outside in the hallway. And the judge goes, "Well, I have I do have an oath of office, but I don't have it with me." And she goes, "Well, Your Honor, you're supposed to have it with you, and this is my argument. And they have all this evidence that's not evidence, Your Honor. You know, I put this stuff in." And the judge goes, "Okay, I'm going to let you talk when we come back in. I'm going to let you talk. All right?" And she says, "Yes." So they go back in the courtroom. Okay.
Uh-huh.
Then the judge puts his robe back on, sits on the bench. He goes,
because it was off record. He had to be out of the.
Well, that still sounds like ex parte communications. Robe on or robe off?
No, it was a equity. Technically, that was exclusive equity. Because he was changing his hats. But anyways, so you move forward.
Wow.
You move forward, right? So then he immediately turns to the counsel and goes, "Well, you know, I see here," he says, "do you have the original note?" "No, Your Honor, we don't ever have to have the original note. We just submit these documents." He says, "Do you have the assignment from this party, and this happened, and this happened?" And he goes,
Let me look.
He goes, "Just a second here, just a second."
That's a transfer of
He goes, "Well,
property, right?
He goes, "I'm dismissing this case." And he says, "But before I dismiss it," he goes, "I'm reading this into the record." So what he does is he reads her truth in lending violations into the record that she put into the case. He reads those into the case, and then he makes a statement. He says his statement, he goes, "I see in this record that you guys violated the 90-day thing for the trustee deed law. You violated the 90-day thing. You didn't do this, and you didn't do this, and this here." And he starts reading off her violations, right, under truth in lending. This violation, this violation, this violation, this violation, this violation. "And so because I see these violations and the fact you didn't follow this thing wasn't done right, I'm dismissing this case." You know what that did?
What?
He dismissed it, and he said that he found what in the record? The violations of the truth in lending and the violations of the 90-day statute for how you're supposed to do a foreclosure in the first place.
Mhm.
Because those violations were found in the record, even if they appeal, what's the next appeal court going to say?
See you later.
That was found in the record. He found that in the record under her testimony,
Wow.
right?
Yeah.
So, from what I've known, it's been used in 3 foreclosure cases, only one that I have personal knowledge of, and the cases were dismissed.
So the judge acted to put evidence in the record.
He put evidence in the record so they can't appeal. Why? Because the court lacked jurisdiction. Why did the court lack jurisdiction? Because didn't have his oath of office. Because he didn't have his oath of office, there is no court. But he can dismiss a case. But he cannot dismiss a case with prejudice, because if he dismisses a case with prejudice, he has to have jurisdiction.
Right.
Okay, so they could make the case all over again if they wanted to
Well,
against
they
this
can't.
woman.
Even if they were to refile that case, they would never win. Why? Because the statement by the judge was, I found this in the record.
Himself.
From her. He says, defendant's testimony here in the record.
It's validated. Yeah.
And he validated her and said what it was that they did wrong. There's no way they want to ever appeal that case.
All right, because then they got to go up against that judge and the fact of the reality of what he found on the record. How can they dispute that, right?
And then the next one goes up. Well, he found it through her testimony, not their testimony, her testimony.
Right.
But he didn't say that testimony was a testimony outside the courtroom, or that was a testimony within the courtroom, or that what testimony was within what he was reading in the documents.
That's true.
Well, that's kind of a trick.
Well,
I mean, I don't know how he could take off his robe and then talk to her in the hallway.
Because he's changing jurisdiction.
Wow.
There's multiple, how would I say this? There's 9 different jurisdictions overlaid the United States. Well, I'll just say 9. Okay?
Wow.
You have military jurisdiction, you have
okay.
common law jurisdiction, you have
SpongeBob jurisdiction.
military rule.
Yeah.
You have Roman equity overlay.
Yeah.
Which
By
is
the way, you know what
statutory.
Gary's saying with SpongeBob? He's saying admiralty law. Okay.
Yeah, I know. Well, there is a part of admiralty that I like, which is Rule E8, which is special appearance, which E8 and E11 doesn't allow the lawyers to talk.
Ah! Hey, Elizabeth, shit.
So,
wow.
and then
Well, I'm going to be listening to this show 10 times over, and we're going to be bringing some of this stuff to the Gary's federal case. He's in forfeiture courts. He has.
You also have what's called a motion to disqualify opposing counsel. And you have to file it. You look at the court rules as to how many days you have to have before you file it in the court record. If it's 10 days before the hearing, you file it in the court hearing. You file it in the court record. And then you serve it on the other party later.
Okay, can I ask you a question? What is technically a hearing? You have to show up, you have to be in court, correct?
Well, a hearing is when you move the court to do something.
Okay, so it could be off the papers?
It's everything. It all deals with paper. It doesn't deal outside paper.
Unless he takes off his robe and goes out in the room. Now,
if he does that, or if he stands up and turns around and looks at the wall.
Question. Wouldn't it just, these judges already
I wanted to hear that answer, Gary.
Frank, hold on. Wouldn't it be easier if all judges, when they come in, they already have it like in plastic on their desk, just in case anyone asks? That should always be there, or am I speaking stupid?
Well, here's the trick you can do. You walk in the court and you tell the judge, is this equity? No, this is law. Oh, okay, thanks. So now I know what jurisdiction it is. Well, if it's in law, Your Honor, you have to dismiss the case immediately because there is no injured party. There has to be an injured party in law.
Gary, you can use that in your forfeiture case.
So
I don't want to decide where he's going, but yeah, again, we're gonna have to listen to this 10 times with each other, Frank. But yeah.
so anyway, so basically, I'm sorry, I'm jumping around a lot. I apologize.
No, I love it. Keep going.
But basically,
By the way, you're our best guest yet.
Thanks.
Go ahead.
It's because the Holy Ghost is in me, not.
Hey, amen. Some of them we had on also Christians. So, but if you really notice, those who really care about the law of what I come to really see, I don't mean the blood bar cultists and all that crap. I find them now they're serious and take it seriously are Christians. Maybe it's just me. I'm not stereotyping. I'm just saying by my observances and what I've had on this show and talked with others. I just want to make a mental note. But go ahead, sir.
Okay. So basically, the constitutional question helps out a lot, right? Mm-hmm. In the cases and other cases, civil or criminal.
Okay. Can I ask a question?
Yeah.
You named the 9 jurisdictions or possibly more, right? Which jurisdiction trumps the other jurisdiction? Is the military jurisdiction the most powerful?
No, the most powerful is exclusive equity. Exclusive equity is inside the judge's chambers, and he ignores whatever the attorneys are there as volunteers.
Wow. I thought I knew law, but you're showing me I know nothing.
Me myself, what's equity? Like people say equity. We're not talking.
Well, equity is a loose term, okay? Because when the judge is stating equity.
Yeah, we hear it all the time. And then,
the judge is stating Roman equity law from Rome.
Oh, another foreign law in our American judicial.
No, that's how we have statute, and Roman equity law comes from statutes. It comes from Rome.
It's the evolution of our law today.
It's a Catholic Church.
I see what you're saying.
That's why there's 4. I don't know. There used to be 6 Catholics on the Supreme Court. I can't remember how many's on there now.
So I'll get into that.
So, but anyways, so it's basically you have law, so then you have restrictions of law. You can put what's called the law of the case in, right?
Okay.
Now my fundamental beliefs of how law works came from Richard Cornforth. And he says it's all there. That when a Supreme Court issues an order, right? The Supreme Court's ruling over is telling you what it is. Like the right to travel, always been a right to travel, right? You bring up the case, they dismiss the case. It's going to get dismissed. If there's no criminal side to it, they don't want to do this. This is what happened to my friend Larry. Okay. So I put all this stuff in, put the other stuff in, put the brief in for Dershowitz and all the exhibits A, B, C, and D. Okay. His was the fastest case. The judge goes, is Mr. Eberhardt here? Oh, I'm going to back up. The strangest thing, Larry's in court. Larry's been in court several hundred times, hundreds and hundreds of times. Larry's been in court, right? So he gets to court, and the bailiff says, don't stand when the judge comes in. And he's like, what? He says, this is a continuation of the court proceeding before, so therefore you don't have to stand. And Larry goes, okay, it's kind of strange. All right. So then the judge goes, Mr. Eberhardt in the courtroom? Yes, I am, Your Honor. Are you having a good day? Yes, I am. Thank you for asking. Mr. Prosecutor, is there anything you want to say before we start trial today? Yes, there is, Your Honor. We're dismissing the case with prejudice. And Larry turned white as a ghost, couldn't really, lost it, just checked out for a few minutes, right? And Larry goes, what did he say? And the judge goes, Mr. Eberhardt. He says, you're free to go. Have a nice day. And thank you. And so, and then then my friend Lance grabs Larry and takes him out. Sits in the hall. Larry's white as a ghost, like no color in his face. He's like in shock and all this stuff, right?
Oh, what just happened?
And he goes, so then they go eat, and it takes him about 15 minutes. He's sipping on a cup of coffee, and he goes like, "What happened?"
Does this have to do with standing up?
It had to do with the fact that there's no way the court wanted to go to trial. How do you overturn 51 Supreme Court cases?
In
And
a
it
shop?
was
You
and
don't.
it was brought under the supremacy clause, which makes the court have to see it.
Okay.
There's other things you say when you quote a case. You don't say you're quoting the case. You put the Supreme Court says blank. You don't say
Interesting.
you say it, because you saying it is an opinion, just like the attorneys, and they can ignore the opinion.
I see. Yeah.
I'll definitely utilize that from now on.
No, we've been doing it properly. We just put the cases forth. But go ahead.
But no, what it means is the Supreme Court says blank, then you list the case, the header, right?
Hmm.
So it's just really, I find it really fun. Okay, so we're gonna go to a fun case. Okay.
Especially when you win.
Okay. I just want to have time for the Brunson case, but go ahead.
Okay. Yep. Well, this is a debt collector.
Yeah.
Okay, I'm going to read the affidavit of the person accused by the debt collector. Okay. I, Arthur, of age and competent to testify, state the following based on my own personal knowledge. 1. I'm not in receipt of any document which verifies that I owe Compass Bank money. 2. I'm not in receipt of any document which verifies that I owe Persol Law Group LLC money. I'm not in receipt of any document which verifies I have a contract with Compass Bank. I'm not in receipt of any document which verifies that I have a contract with the Law Group LLP. I'm not in receipt of any document which verifies that there are any receipts signed by me proving the amount of the obligation.
Hmm.
Number 6, I'm not in receipt of any documents that verifies that Compass Bank has standing to sue in any California courts, virtue by being registered duly elected. Compass Bank meeting the minimum contract requirements in personam jurisdiction. And then basically the law group not being there. Okay, not having right to be there. Now here comes the zingers for him, right?
Yeah.
This case was a debt collector case on a visa for $50,000 roughly. And the plaintiff, after this answer was filed, dismissed his case with prejudice. Here's why. Number 8, Compass Bank, N.A., is an instrumentality of the United States government and an agency of the federal government. See Davis versus Amelia Savings and Loan Bank, 1896.
When you have a case that old, though, how do you really?
Never overturned. Doesn't matter. Still relevant because they're all instrumentalities because they all get their charter from the Treasury. The U.S. government issues money in advance of national banks in exchange for promissory notes. See Cook County National Bank versus United States. Also see Federal Reserve publication title Two Faces of Debt, 5th version, September 1992. I'm not in receipt of any document which verifies that the legal group LLP has the authority and authorization to represent the United States government. Plaintiff is not provided an affidavit from him or his client proving up his claim in the complaint the court is in want of subject matter jurisdiction. 12, as a result of harassment of the attorney's name, I have been damaged financially, socially, and emotionally. And then it goes, Mr. Arthur, I am the defendant in the above entitled action defendant case. I have read the above defendant's special appearance, Admiralty E8, restricted appearance, verified answer, and plaintiff's complaint. Plaintiffs, I have compiled and testified, and he goes through all the stuff and it's notarized, right? So he notarized his thing. So there you go. Now those two Supreme Court cases, that's why no bank can foreclose on any property, because no bank has the right to foreclose on any property because they gave up the right when they went to the window at the Federal Reserve. So this got them to dismiss their case. Okay, now bring in that other case you want to talk about.
Well, the Bronson case that everybody's talking about today that went to the Supreme Court, which had the power to overturn the elections, had the potential, I should say,
Right.
to overturn the elections. It finally they jumped over the district court. They went on Rule 11. They got in to the United States Supreme Court, and at first it appeared that the Supreme Court really wanted to hear the case, but when push came to shove, in the end they just denied it. So now Bronson's moving to appeal, and you're saying he's doing it with a reconsideration, and you just told us that a reconsideration has to come up with something new. So
it has to have foundational new evidence written the day after the order was issued. Anything after the day. Yeah.
Really? One day?
So if it was like, let's say for instance, the order was issued, right? On the 24th, Tuesday the 24th, right?
Yeah.
Any court case, any findings, anything you could find on the 25th forward, you can use. Anything on the 24th back, you can't use.
Oh. Huh. Well, that's weird.
Yeah. That's what I found out because I lost one.
Okay.
So that's why
Okay.
It compels you to find new and other evidences, even if the judges or judge didn't even look at that stuff or just said denied.
Right. That bothers me. What Gary just said. Okay.
Mm-hmm.
They don't even read my pleadings. I'm sure of it. And,
well,
the
ones that read appeals or the appeals court read. They like to read. Those guys like to read. The problem is you can commingle two arguments together and you lose the jurisdiction that you'd win. An example is if you want to claim equity, exclusive equity, you can't claim any UCC numbers or UCC filings or case laws or any of that. It has to be strictly equity. And everybody, if somebody sues you, like physically sues you, right? I'm going to be honest. I got one guy called me up on the phone and told me, I'm going to sue you. I says, okay, all right. And this was my response. In the middle of the night, do you dream of how to sue credit bureaus, collection agencies, and banks? And he goes, no. I says, I do. That's my mission. And I say, and he goes, well, what do you mean? I says, well, you're suing A. A is a Colorado corporation. You're suing a Colorado corporation. I'm going to walk into court and all I got to show is inconvenience. And the inconvenience is going to court. It's not the day-to-day business of this corporation to go to court. Therefore, it's an inconvenience. It's an automatic judgment of $250,000 you're going to owe me before we even start with triple damages or other damages I could think of. And all I heard on the other end was click. There was another example of a party saying that somebody signed a card with a corporate card with their personal name. And the party was instructed that to never sign his corporate card with his personal name. He always signed the corporate card with the initials or the name of the corporation, not his name.
Okay.
His name's on the front of the card to show that he can use the card, but it's not his card. It's the corporation's card. So he who signs the back of a credit card is the one that's liable,
Okay, right. That makes sense.
not the party. So so they told him on the phone that they were going to find where he signed it. And the bank called him back. And the guy called him back and said, "We looked through every time that card was used and signed, and it was never signed with your name."
Hmm.
And the guy goes, "You're a son of a bitch," and hung up the phone. And he was never sued, and the company was never sued. But it's knowing how to sign things and how to do things. That's one thing. But okay, you're talking about that case. I'm going to show a flaw that could be in the case, right?
Mm-hmm.
All right. Go back to Gore versus Bush, right?
Right. In Florida.
In Florida, and the one lovely judge. I just love the judge. She was so nice and so happy and kind, and she just went like that. And she goes over and has the bailiff go over and grab a thing out of one of the voting things. And this is what she said: "Did you go over to those boxes and take one of those things out, one of those voter pamphlets out, call the person, bring that person in, and have that person say which way he voted?"
Oh. No.
Do you want to make this a constitutional question? No, 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 Your Honor. We do not want to make this a constitutional question. No. And then Gore lost, right? It was a dog and pony show, because all they had to do was bring in one voter and pull her voting badge from that group of ticket, hand it to her, and ask her, is that showing the way that you voted? No, Your Honor. This is not my ballot. I did not vote this way. Then guess what would have happened? All those ballots would be taken in as evidence, and they'd have to go through every single one to see who voted what, voted who, and who voted when. But because there was no voter involved, it's a bunch of crap. They can't do it. You can't do it by a group of people. Huh?
What's wrong with Arizona then? You know, what's going on there in Kari Lake, and how Twitter seems to be blocking her and her efforts.
That's another. Which question do you want answered?
So basically,
I saw three questions in there, Gary.
So basically, you have to have evidence, okay?
Mm-hmm.
But you have to have a party that can bring the evidence in, and only a voter can bring in that evidence with the vote. He has to challenge the vote by his vote or a group. Because you have to have written in stone, sketched in glass, and written on paper. It has to be a competent fact witness. Without a competent fact witness, there is no case.
Well, what about mail-in ballots?
You'd have to show somebody doing it. There are people that are working on that, so they are changing the voting. In one state, in several states, it's illegal.
And that was only enacted because of the commie virus and the commie shots anyway. So why
Gary, that's your terminology. But say it plainly, because
basically, there was groups that videotaped this one, and there are people in Pennsylvania being prosecuted right now.
Nice.
It didn't, and there's people I think in Atlanta that are being prosecuted. Good. And they use the cell phone data to prove who the people were.
Right.
Yeah. So there are people that are being, but that still wasn't enough votes to persuade there's not enough outcry, and no voter is the one that's going forth and saying, this is how I voted and this isn't how I voted.
Oh. Right?
Because there's no voter saying that, there is no standing for anybody else to go after it. The individual voter himself has to go there, and they had to have done his vote wrong.
I see.
Or by bringing him in, he's a vote. So now they have to look at all the other votes. So now they have to all of those cases, that van they watched driving all over Florida with the votes, right?
Yeah, yeah.
All of those votes would have to come in because you had one voter. This one's right, but I think those are wrong. And then they'd have to go through and look all of the votes. They'd have to tally them all
Millions
up.
of votes, if not hundreds of thousands.
Right. And if he voted and said, that's not the way I voted, this is the way I voted, then every single one of those documents, that voter would be allowed to bring in all of those votes.
Do you know what I saw yesterday on a blog? Somebody went into a ballot, ballot box, I guess you call it, with the curtain, and she took her cell phone and she's putting it over the voting thing, right? And she chooses one candidate. She's pressing the button, and it checks the other candidate. And then the screen goes, you entered your vote, the check is for the opposite candidate. And that's like amazing evidence. So I was like,
well, I
you're
know
saying
they're gonna throw out thousands of voting machines in Arizona and thousands of voting machines in Florida.
Right.
They threw out.
Good. We shouldn't even be using them. We don't need the voting machine. Papers and voter IDs.
But basically there's
Election date, not election month.
yeah, it should be, we'll see what happens.
This is one of our most sacred rights, elections and voting. It's the foundation of America. So it's very, very important. I mean,
it's a national security, literally. Literally.
I would call it a national security problem. Would you,
Yes.
James?
Yes.
Yeah. But proving it is another thing.
Huh.
Knowing that something happened and proving something happened, you have to have the evidence and the competent fact witnesses. Now, that's why I like the law, because eventually the law,
Well, they have the
truth comes out. Well, they're changing things. The states by states are changing things.
Yeah, they are.
To make it more complicated in some states and less complicated in others.
I don't know. That's backwards.
Because they're all upset about the law that was passed in Atlanta, but the law that passed in Atlanta said you had to have ID.
Right. Need ID.
which I think is a good idea, right? To have a voter ID.
Yep.
Oh,
That's going to stop an enormous amount of fraud.
Yeah, they want foreigners also, non-citizens voting in our elections. This is no better. Even Banana Republic.
That's the point.
Well, here's the problem, gentlemen. You have multiple different. There's only 2 citizenships in the United States. 3, well, technically 3. you have non-resident alien, which I am. I'm a non-resident alien, which means I'm an American national.
Okay.
If you are a United States citizen, then you are basically don't have any rights.
What?
Please explain.
A United States citizen is under the United States, which if you look under Title 28, you go down there, it tells you what a United States is, and the United States is a governmental corporation.
So we were usurped. We the people were usurped of our Constitution, and thus the original 13th Amendment. This falls
we were.
Is that because of the 1879 constitutional change?
No, it goes to the 14th Amendment. The 14th Amendment made everybody in the United States a slave.
But that's antithetical and to the Constitution.
Because the wrong parties are voting. The people, when you say vote, they're not voting. The people that are voting are United States citizens. They're not United States of American citizens. And
Okay,
there's a
so how do you categorize yourself as one of them?
well, you would have to do certain things. Like, for instance, a friend basically went down and did a name change and corrected all of the presumptions of his name and his status. And basically,
To who?
he did it in court. And then he took that court document, the decree of the court, which he wrote the decree and the judge signed it. And then basically he took the decree, sent it to the attorney general of the state that he lived in.
Mm-hmm.
They changed the birth certificate. It says his Christian appellation name on the top, says the state underneath his Christian appellation name. Then it says his DBA name, which is the all cap name, is under the state. And then
doing business as.
And then that's it. So he is above the state on his birth certificate.
How many people ever do that?
Very few.
It sounds so damn backwards, though.
Okay, I got one for you.
It
Well,
does.
People are saying the United States corporation is bankrupt.
It can never be bankrupt.
It was
impossible.
ruled in a Florida court.
It's
that it was bankrupt.
It's impossible that it's bankrupt.
You know about that case in Florida? They ruled the United States corporation bankrupt.
Well, the one is bankrupt, but I'm saying the United States of America isn't bankrupt. The United States isn't.
I get
well, no, the
corporation-
United States corporation is not bankrupt either. It's under bankruptcy proceedings.
Yeah,
but it's not bankrupt.
I thought they concluded it was in Florida.
No, they
had that case a couple of years ago, a year ago.
It's never been out of bankruptcy.
Okay, if you have a bankrupt corporation, any corporation, right?
It can still do business. It can still be worth billions.
That's why they hate Alex Jones also.
Yeah, I like Alex Jones too, but I mean, basically they can't. It's impossible for the federal government to go broke because the federal government owns all the properties in the United States were all ceded to the United States in 1933.
Yeah, talk more about that. That's entirely interesting.
Let's see here.
A minute. Then does that mean, like you said with slaves, what we are the products? We are the products, and what happens when a company falls? Who comes to that maybe that is owed, that took loans, and the company falls, the new company comes in, cleans the products off the shelf. Do you see
it's like you go to corporate law. Corporate law is fun. I love corporate law, but corporate law, a company can is this it? This might be it. This looks like it's old enough. Nope, that's a deed of trust. Nope, that's the wrong yellow folder. Never mind, not that one. Tablio, there we go. You guys just saying I'm a treasure trove of stuff, huh?
Yeah, you are. But you're also
hopefully you'll come back on the show again at some point.
Yes, I will.
What we'd like to do is take your statements in this show and then have people come in and want to debate those points with you.
That's funny. Yeah, it's Senate document number 43, 73rd Congress, which the ownership of all property in this state, individual so-called ownership, is by virtue of government, i.e. law, amounting to mere use, and the use must be in accordance with law and subrogated to the necessity of the state. That's a capital S state.
That doesn't seem just, but go ahead.
Congress recorded March 9th, 1933, H.R. 1491P, page 83. Under the new law, the money is issued to the banks in return for government obligation, bills of exchange, drafts, notes, trade acceptances, and bankers acceptances. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation in the representing a mortgage of all of the homes and all of the properties of the people in the United States, in the nation.
What, like we're property? What, they can sell us?
Yeah,
No,
what happened
the
to
land?
Am I hearing this right, first off? I mean, I'm trying to follow you, so forgive me. But that sounds
Okay.
like, hey, what you mentioned about properties, mortgages, people?
It's a mortgage of everything.
You're saying they own us and they can do what they want with us?
They put a mortgage on all land, all minerals, all water.
All right, we know that.
Yeah,
So what if you paid off the mortgage?
and the people output. No, there's only one way you can get a absolute mortgage, absolute title.
Yeah, how do you do that?
You have to get it issued to you, and I'll just say there's a way of doing that. I can't say it publicly.
Ah. I'll give you
Okay,
another-
you got smoke coming out of my ears.
Because some things can be said public and some things can't.
Well, law should always be transparent in public, right?
Yeah, but that there's certain reasons, because if it's private, it's private. So in a private conversation, I could say
What
it,
about-
not in a public conversation.
Okay, well, what about just compensation? You
Therein
know,
lies their problem.
They can take your property with just
Well, what I can say is one lawful dollar can pay off fiat money owed to the IRS.
Huh.
equivalent fiat money.
$1 is the equivalent of any fiat money,
Of any volume
of any
of fiat,
volume,
any volume of fiat money.
because one is lawful and one is debt.
Okay, what do you? Let's then
Plus
take.
the dollars.
Let's segue a little bit. Oh, so we're going into a new quantum financial system. We're getting rid of all the world's fiat money. How is that going to change things? And that's happening as we speak.
You can still buy lawful money.
Well, what do you mean by money?
A lawful dollar coin is still able to be used.
$1.
Is that a gold-backed or mineral-backed or acid
Silver.
currency? Yeah,
Silver dollar, 4 quarters.
right. So that's what they're doing. They're going to make everything gold back. Even they're going to make the digital
what
currencies.
I'm saying is,
Yeah.
is that money will always pay off under the 17 something Mint Act, Coin and Mint Act, states what a dollar is, states what lawful money is. I mean, I have a brief on constitutional money.
Right.
And it
Well, the
basically
dollar today is merely a promissory note.
there's a difference between the dollar and
Yeah.
the rest of the U.S. money. If you look at the $5 bill and the $1 bill, you'll see there's a distinct difference between the two.
Okay.
Well, I mean, one is $1 and one is $5. What else?
No,
One has a different image on the front.
one says note,
Yeah.
Reserve note.
the others say Federal Reserve System.
Ah. Oh, wow. No shit.
Well,
And
I'd have
there's-
to meditate on
There,
that.
there's the things that the $1 can do that the rest of the money can't do.
Like what?
Extinguish debt.
So if you have enough.
So
of
when,
those-
so when, so when, let's say, for instance, somebody sues you, right? Let's go back to lawsuits. Somebody sues you, right?
Okay, right.
There, you have to put in your. You've always heard you have to put in your affirmative defenses, right?
Mhm.
Okay.
Your first affirmative defense is not an answer. Your first affirmative defense is not notice of constitutional question. Your first notice of offense is an abatement, notice of abatement. Then a motion to dismiss.
Oh.
Then an answer in affirmative defenses. That's the order you're supposed to do it in, and Gibson says it in 1874 in the Gibson book on equity, Suits of Equity. So there's a series of things you can do, and there's a series of things of how to claim your right to be who you are. For one, I can go back to a case on the first time I've heard of a case, the first time something ever happened where it got sealed.
Mm-hmm.
There was a summary judgment of eviction. We put in that the breath that I'm a creation of God, or I'm a creation of the Creator.
Right.
And then we put in Genesis, and then said that God formed man from dust and blew breath into his nostrils. In the court case, I am an act of the Creator. I am alive.
Unbelievable. Unbelievable defense.
I'm alive. And then we went into this section of how certain spots talk about I can find it here in a second. I want to say it's 5222. I think that's right. We'll see if my memory's good here. We'll see if that's right. Internet. There we go.
Okay, while you're doing that, that
Yeah.
all pertains to Jefferson's creation of natural law, right?
No, there's natural law, and then there's unwritten law. And unwritten law is the highest law.
Wow. And that's what you're working with right now, what you're talking about. Right?
That's part of unwritten law.
Yeah.
It's from the Creator.
Unbelievable.
And here it is.
And it's a far fetched. They want to take God out of the country, out of the system. Like
Well,
Kamala.
they can't because
Kamala Harris the other day.
Yeah, let him answer. Let him answer.
Ronald Reagan put the Bible. Ronald Reagan put the Bible in as law. In an act of Congress, it was signed.
Okay.
And they're never going to repeal that.
No, that's good. Now, here's what I was talking about. Kamala Harris the other day. I don't know if you guys seen it. She got up there touting about the Constitution, right?
Right.
Basically, she made like our rights sound like they're privileges. She took out about inalienable rights.
She talked about the right to life is what she left out.
She also said she left out about God and the Creator. That's
right.
The thing in the Constitution. She deliberately left them out, therefore trying to make it appear like it's privileges. No inalienable right by a divine Creator, as a sense. Do you guys, you didn't see her the other day?
Right, she said that, but she didn't say which Constitution she's referencing.
Ah, exactly. They're democracy.
No, they're referencing one that's not the one written on lamb skin.
Oh.
What do you mean, the Ten Commandments?
No, the parchment is lamb. It's lamb skin is what it was written on. It's a type of parchment. They wrote it on something that would stand the test of time. But anyways, this is what I was right. It was 50-2-22.
Mm-hmm.
State government boundaries and jurisdictions of the state. Article 2 jurisdiction 50.2.52 constitutes acquisition of United States and lands of government processes, right? The Constitution, or sorry, not the Constitution, the consent of the state is given in accordance with Article 1, Section 8, Clause 17 of the Constitution of the United States to acquire the acquisition by the United States by purchase, condemnation, and otherwise of any lands which have been or made acquired by assets controlled, customs houses, courthouses, post office, and erection of forts and magazine arsenals, dockyards, and other needful buildings. Okay. It means that these things, right? This stuff, let's see if I can click to the long version. That's the short version. Anyways, that means that all of the territory of the state is not the state. So what territory do they do not reference everywhere across the United States? What is the one thing that they do not say anymore?
What?
The Union.
Oh. Yeah, they assert the
Everything,
union.
everything that the House of Representatives controls all of the territories of the United States. So the House controls all the territories.
Okay. And the Senate
controls the entry into the Union.
Huh.
So again, which constitution was Kamala Harris referring to?
Not one that anybody is abided to follow.
Bingo. It just sounds so unnatural anyway.
No, you want the 1793 one that was on parchment.
Of sheep.
Not the one that was on paper. They're referring to one that's on paper.
Gotcha. Huh. I wonder what else changed in all that.
Huh?
I wonder what else was changed in all that.
Okay, well, when the changed constitution, was it 1879? Did I get that correct?
I think there's 1890 something. It's either 1889 or 1891 or something like that. I know. Like Washington State, where I was born, it has 4 constitutions.
Okay, well, getting back to my question, is that they put the United States of America in all caps. Does that really make a difference? This all caps argument, does that make a difference?
It does in the individual's name because that's an estate that was created by the Social Security Administration.
Can you disavow being labeled in all caps, having your name in all caps? Can you claim that it's not you?
Right, like you're a product, you're a store, you're a what?
You're the registered agent of it. Well, technically, the Social Security Administration issues the Social Security number is a Social Security Administrative Trust Corporation. It's a corporate structure under their trust.
Okay.
So the answer to your question is yes, you can. That's why you would have to do a name change to say who you really are.
Mad Martian.
So you say who you really are, where you're from. There's a way of doing it.
Very interesting.
I can say I can relate to being a Martian, right? Since there's 52 genders, I mean, equity, all this other stuff. They say that's equity. Hi, I can say I'm a robot. Bleep, bleep, blap, bleep. You know,
That's all Roman equity. Because those are all privileges that they're trying to promote.
But under natural law, we have rights. And they can't be taken away and made a privilege.
No, that's why the case I read you. That's why these cases get dismissed
Exactly.
because it
People are not
says you cannot.
pe-
I'll
people are
read
not
it.
doing that enough in the courts.
I'll read it again, just because it needs to be clarified.
Cool.
No state shall convert a liberty into a privilege,
Right.
license it, and attach a fee to it.
Exactly.
Wow, take your commie shots and you could go to a movie. You could go to a football game. Boy, a lot of rights being infringed there.
Can I ask you a question?
Yep.
Why should I pay court fees? It's our right to. All courts are open without delay.
That's
was
what the waiver of informer pauperis form is for.
Informer Popper?
Or I'm sorry.
Papyrus.
Papyrus.
Yeah.
I still don't know what that means either way.
That means that you're too poor to.
No, that you don't have lawful money of the United States. None of us are paid in lawful money of the United States.
Interesting. I never heard that interpretation.
So basically, and if somebody sues you, this it's a 77. I'll have to get the thing for you guys, but if anybody goes to garnish wages for child support or anything, for debt, credit card debt, all that debt. I mean, credit card debt can't be transferred to anybody. So once they transfer credit card debt to another individual or to a company, the debt dies.
Okay. Just credit card debt or all debt?
You could argue that all debt can't be transferred.
Well, that would. What about this derivative market on mortgages? That would make it completely illegal.
Well, the derivative market would be your collateral trading on the open market. Your collateral.
If you don't know nothing, you ain't got collateral.
So if you were to take if you were to go back to the original land patent in the area and claim it forward, and all rights, transfers, and taxes, tax duties, transfers, and all the transfer taxes forward, and claim those forward, you would have to be paid. I mean, you'd have to claim all rights, titles, and duties to go all the way back and do other paperwork. There's a way to do it. And now you flip that on them and you send that to them, then they basically have no reason to foreclose on you. But there's a way to do that. But
okay, are you the only one who's done this kind of procedure? Are you the one who invented, or saw the? I mean, where'd you get all of this knowledge?
People send me shit. Okay, I'm gonna be honest. People send me stuff. Does this work? Oh hell no! Run from that shit. No. And then they send me other stuff. I go like, oh well, that piece right there works. So over the last 30 years, I've probably I've probably been involved with over 1,000 bankruptcy cases and probably about 450 credit repair cases that all won.
Wow.
I had one. I helped a farmer with one case on a RICO against Wells Fargo, which lasted 9 years, or no, somewhere 6 to 9 years, something like that. And they brought in Preston Gates, which is Bill Gates' dad, and he was able to win the case because I didn't know how to state time. And by God, I know how to state time now.
What? Okay. Well, we could talk. We could talk a little bit more about that, but before we do, this is one of the greatest threats to America right now, with Bill Gates buying up all the farmland. Are you saying through this law that you're presenting today, we can stop him from doing certain things with the land?
You're allowed to there's a way to get absolute title. It's not how people normally thought you would get title.
To his land?
To any land that you have.
Well, because what Bill Gates is going to do is control the food supply by being the biggest farmland owner on the planet or in America.
Cells, though, they feeding
Yeah,
the buck.
if
Gonna
he's
let
gonna
us-
if he's gonna live that long.
Yeah.
But
Well, that's beside the point. Let's just take it that he's buying up farmland at an incredible rate. He's the largest landowner, and he plans to
just
destroy
because-
the food chain and have you eat bugs. We're back to
Yeah.
bugs.
yeah, that ain't happening.
Not that right. Not that
Okay,
right.
so he wants to do genetically modified foods, and he wants to have the patents on the food.
Well,
Yeah,
that's
the
a
Hey, all that-
there's a problem with that patent on food thing.
Okay, love to hear it. Love to hear it.
There's a Supreme Court case that's winning on the farmers winning and the big ags losing. He's saying that the basis of their whole thing is fraudulent, and because the basis of their you can't copyright life.
God's creation. They want to replace
And
it.
so they said that they copied a bug. The bug that they copied was a bee. And they said because they copied this, they altered this bug, they're saying
That's theirs.
that was life. They created life. But the problem is they didn't create life. The thing already exists.
They just tincture it around and mess with things of what's already created. You know, these people.
So-
Yeah, but that
So
kills
the lawsuit,
anybody
the
owning
lawsuit,
anything.
yeah, the
at
lawsuit
patent
is-
office.
yeah, the lawsuit is going to cripple corporate pharma
Good.
because they're losing.
Yeah, well, they're going down anyway. They're going to be sued to kingdom come over the vaccines. You want to talk a little bit about the vaccines? You don't have to, but definitely.
I would just say that you shouldn't get the vaccine because it'll kill you. Everything will kill you.
Yeah,
I
let's
mean,
put it bluntly.
All right, but anyway,
mean-
when I was in Connecticut, I actually did commercials for Purdue Frederick, so I knew all about Purdue Frederick. So what they did was they went into opioids. So when I was, 40 years ago, I was doing ads for them for laxatives. And they graduated to opioids, and then the opioid crisis, and then they got sued to kingdom come. There's nothing left to Purdue Frederick, nothing left. I think that's going to happen to Pfizer and all the other companies.
they just filed a lawsuit against the DOJ. Just filed a lawsuit against Google to break up its advertising monopoly.
Good.
Oh, we need that.
This is sick what these people are doing.
But they can't. They'll never be able to break up Gates's companies
Why?
because his dad was the one that wrote the acts.
Oh man, talk about diplomatic immunity.
Well, what
Give me-
difference does that? What difference does that make that he wrote
Huh?
it? What difference does it make that he wrote it?
Okay, he wrote the Antitrust Act. He helped get it written. His dad did. He's still
Yeah.
alive too, which is really freaking. He's old too.
Adrenochrome, fascinating drug.
Well, I mean, he was related to Planned Parenthood and the Sanger family and et cetera, et cetera. All right, so
Okay.
I'm sorry.
They're the enemies. These people are sick. They're the enemies, and that's especially regards to chickens. Notice they're going around killing millions of chickens. Are the farmers able to do anything, sir, that you're aware of that maybe they could use to stop them? Because now eggs are. They want to wipe out eggs and they want to put out their own batch. Even Gates said that. Here's a new batch and type of eggs for you. I don't think so. So is there anything the farmers could do? Because they're even putting stuff in the chicken feeds that's preventing hens and ducks and chickens from laying eggs in the feeds. And
they're making their own custom feeds. I know I have a farm in Nebraska that's making its own.
Yeah, but this was a sort of preventing it, like they have the mRNA crap in it for the aviators.
Yeah, that's the point.
The kill, and to starve. They want millions of. Farmers are having their millions of chickens culled for aviation, telling they'll be paid off. They're never contacted again. This is nuts. For processing plants being on fire. I don't know if there's anything in the law we could do to stop that. But
That's the Antifa guys are doing that.
yeah, the Antifa, yeah, the foot soldiers. Either way, we're at war. So we can't eat the bugs and we cannot allow our children. Is there anything that the farmers could do to say, hey, you're not going to kill my chickens?
Yeah, they've been doing it. They started up other things to raise chickens and stuff. They're doing other farmers are raising chickens
Right, but especially
and
for
ducks.
right? Yep. I
Yep.
love duck eggs. I got ducks and chickens, and I'm gonna get a lot more. I'm just gonna say that.
Mhm.
It's just nuts. See how much eggs are at in the stores? Look, even this past Thanksgiving or Christmas, $50 for a turkey, $50 for a ham, and the eggs are going up. I mean, this is getting ridiculous, man. It's like, people will be raising their noses all the more at other people who can't afford it. And, until it hits them. And then what are they going to do? And I got mad.
It all relates to the price of diesel.
Well, that's true, too. Who gets that? But if they try to stop shipments of them.
Okay, excuse me. Explain why that is.
Because the cost of diesel, if you're in a grocery store, the further they have to ship it, the higher the price has to be on that one product.
I see.
So
Well,
when they
it's not
when
about
the,
them
when the
killing
diesel
millions and millions of chickens, because they did do that. 50 million chickens, right?
well they had tons of chickens were dying for other reasons, not because of that.
They said avian flu, but yet they weren't showing the evidences of it.
No, I mean a lot of them froze
Oh,
and died from freezes and the cold snaps and stuff like that. They died then.
Well, that might be true, but Gary's right as well.
You have
That-
groups that are trying
That
to.
they were ordered to kill the chickens, just like in the Netherlands, they're ordered to kill all the cows.
yeah, they're going to do that here, too. They don't want us eating meat. They
Well-
want us bugs.
Well, I think that the Netherlands people are going to stand up against it.
Oh, they are. They've been protesting even with their, their tractors out. I mean, but when it comes down to it, they have no Second Amendment. We do at the moment. See, that's inevitably
we will
what's going
always have the Second Amendment.
Correct.
But
well, it's going to have to be utilized. And I'm sorry to say that, but look, they're trying to already kill us. They tried to kill me. They tried to kill my family. They tried to kill everyone we know. I ain't following them anymore. I'm sorry. But I'm not sorry.
see, there is a way. You can call me later. We'll figure it out. But there is a way
Cool.
to make things anonymity, so nobody knows who owns anything or who owns what. So they don't know where something's at
Okay.
or what owns what. That's why my favorite state for incorporating is Colorado.
That's where I live, and I have some problems here. If you're ever willing,
Yeah,
Okay.
but Colorado, there is no officers list. It's the only state that doesn't have an officers list.
an office list. What do you mean?
It doesn't have a public list. You pull online and figure out who the officer is. It's against the law.
Oh,
It has a privacy. And in Colorado, you also have a right to. You can go down to DMV and you can change your name.
really?
Because the state has the right to an at-law name change, common law at-law name change.
Oh, that's good to know. Now, does that mean all my debt and everything doesn't follow me or anyone else? I don't think so. Who you are still follows you, right?
No, there's a way to.
Really?
There's a way for somebody to totally disappear from the books, records, and planet.
Wow. We could do a whole show just on that.
Because it's how you control things and how you hold things. Using trust, limited partnerships, corporations, and
that I know a little bit about shell companies.
Huh.
yeah, I'm the expert on financial monopoly.
Well, I'll be talking to you if
And
something happens with me because
so it's about what carrier to have your phone with, who to have your phone with, who not to have your phone with,
Hmm. Yeah.
who gives up information, who doesn't give up information, who's the hardest.
Wow. And you can help with all that type of
Yeah,
stuff. People.
yeah. So I mean
I'm
that
sure you charge a fee, and maybe there's a website people will be able to connect with if they have issues.
yeah, but basically there's multiple ways of doing things through
Okay.
anonymity.
Well, I like the word of that. Anonym.
Okay.
And so, you know, I mean, there's a
I have a
private side
feeling.
and a public side.
I have a feeling from the result of this radio show, because we're going to really network it, that you're going to get a lot of business. The next, the next, the next topic I want to bring up is this idea of a corporation's a person.
Oh, I love that one. It's my favorite one.
Or the money is a
Let's talk about that.
Huh?
or the money is a defendant.
You got to go watch. If you really want to understand corporations, there was a funny film made. I call it funny because it was a documentary.
Uh-huh.
It was called The Corporation. It was done years ago. But there was a lawsuit. You know, everybody knows. And I really went blank on it now. It's the first slave case. Oh, what the hell was that? It's why can't I remember it? Anyways, there's a slave case.
Dred
and the guy,
Scott.
Dred Scott. There you go. Thank you very much. Dred Scott was in the wrong court.
Huh.
And they were telling Dred Scott that there was a court he should go to.
Okay.
They also stated that he was already free.
Okay. Sounds simple so far.
But he lost the case. And there's a reason why he lost the case, was because he wasn't a citizen. And see, there's only one person that can go into federal court. Now, if you really want to understand federal court, you can ask privately, and I will email you videos that I have received from the, God, what is that? I'm going to turn one on and then I'm going to stop it.
Huh.
Let's see. I forgot what the name of the system is. FJTN.
Okay.
The Federal Judicial Television Network. You got that. FJTN.
Okay.
The Federal Judicial Television Network. Now, James Wagstaff could be a cousin. I don't know, but I like him. He's old now, but he was the one that taught the judges on jurisdiction, federal jurisdiction, subject matter jurisdiction, and all these things. And for a while there, I was trying to figure out why I lost one case. Okay. I haven't lost many cases. I've only lost 2.
Wow.
All right.
I need your help, sir. Never mind.
One because I did not know how to say time.
What do you mean by that?
Yeah, getting back to that question. That's right.
Okay.
Thank you.
I had the who, the what, the where, the why, and the how. And the only thing I was missing was the time.
The when.
Uh-huh.
Huh.
And I made a statement at all times, 24 hours a day, 7 days a week, they were committing these acts. Then I would have won.
Wow. Wow.
So, but at least I did cost the law firm somewhere around 140 million for a $5 million farm. But anyways, in legal fees.
Wow.
Because we had the farm was separated. The lawyers of the law firm had to each get a lawyer. The lawyer for the accountants had to get their own lawyers to represent each one of them. So it split it up. Each one, the law firm could not represent the bank, so the bank had to go get another attorney, which was my luck, had to be Preston Gates, anyways. But and he won. and he won on a motion 9. Motion 9 to dismiss because I did not state the time. My pleadings were deficient.
Huh.
But at least I cost him that, and the farm was able to collect $20,000 a month for a good 9 years, something like that, 6
Right.
years, because they rented out the farm space. They no longer had cows, but they rented it out to another milker, and were able to make money still for a while. So they got their retirement money.
That's good.
Yeah, they love me. But
I hope they took care of you.
I did that for free.
Can I ask you? I was just going to ask you, sir. Do you do pro bono work by chance? I got some things I need to talk to you about.
Okay, well, later.
Yep.
later.
Yeah, but anyway, so basically the Federal Judicial Television Network had these things on how they teach the judge the subject matter. You're looking at the judges shaking their head going like, oh my God, I didn't realize that. Oh my God. You're looking at the judge, you're laughing like, yeah, okay. So now I know exactly how they proceed and how they do it. And I can even reference this person's material and I'll click in their head and they'll go, oh, well, this is why we should rule because Wagstaff does say this. This is what he says. This is what he taught us. He's the one that teaches them all. He's a teacher.
Right.
They all become judges, so he's the one that's embedded in their brain. So I learned I learned why. Because there was 2 parties that lived in the state of Nebraska, and the trust was in Nevada, and I was in Nevada, and the other corporations were in Colorado. So we had Colorado jurisdiction, we had Nevada jurisdiction, we had Nevada. So I was thinking, yeah, okay, it's going to work. I'm going to get it removed on diversity. It didn't work. And the reason why was because the husband and wife that lived in Nebraska both lived in Nebraska. Had one lived somewhere else, I could have taken it up to district court.
Okay.
But now I know there's a way to show that the case is worth more money. And you go to the comptroller of the state. In the state courts, they have a comptroller officer in each courthouse. And you ask them for a printout on the docket number of the value of the docket number will be somewhere around $2 million.
Really?
Now you can take that docket number and remove it to federal, and you have it because you have the case is worth more than 2 million. And so then the federal court, then you basically make it under the value. It's more than 75,000. So now you have a way of proving the more than 75,000 in value. So that's what we found out the other day.
Right. I get it. So you can have a higher award.
Yeah, because this is what I did, which my friend said was brilliant. And at the time I was thinking, well, it was out of necessity.
Hopefully it's being done in my case.
So when they removed it to federal, I amended the lawsuit because they hadn't answered. They just removed it. They didn't answer the case yet. So because they didn't answer the case, I amended the case, amended the filing in federal court, and the case stayed in federal court because I added the reasons why it could be there.
Because it was dismissed at the original.
Right. Everybody will argue, oh, this is a constitutional issue. Right? This is a constitutional question. Well, because you didn't say it arises out of this section of the Constitution, they can dismiss the case and say it doesn't state a constitutional question. Even though you say constitutional question on it, you didn't state how it arises out of that part of the Constitution.
Well, you have to have the question. And it should mention how it arises out of the Constitution.
No, you have to state it in your complaint.
Right.
How it does. Specifically.
Well, that makes sense.
So if you don't state what section of the Constitution, or it arises out of a treaty, or it arises out of something else, you have to say how it arises out of there. Now they're stuck with the question. Now the federal court has to hear it. Because in all civil actions, the federal government considers that they do not have any case. Any case that goes civilly to the federal government, it says, no, we do not have jurisdiction. That's how they look at it from the beginning.
So how do you fix it again?
You have to say how it arises out of something that the
Right.
court has to be able to hear.
Gotcha.
And what you say, it arises out of the Fair Credit Reporting Act, and this is section this is violated, and section this is violated, and that act allows you to sue. Some federal acts don't give you a right to sue. Like, for instance, the 14th Amendment has an enactment clause, an enforcement clause, an enabling clause, and an enforcement clause, right?
Mm-hmm. Mm-hmm.
Guess what? Guess what constitutional one doesn't have an enactment or enforcement clause?
What?
The IRS,
Ah.
Title 26, does not have an enforcement clause, and it's not criminal, so you can be a quasi-criminal, but you're not a criminal.
But they take it. The IRS takes you to court, and they could win.
Okay, here's how you answer a subpoena from the IRS.
Yeah.
They're asking for your W-2s, your 1099s, and your 402s and 506s and whatever number they can come up with, right?
Mm-hmm.
And you write back the answer to the subpoena. What you're asking for is not in my custody or control. And you've answered the subpoena.
Whose would it be under? Won't they?
Where are the documents at that they're requesting? They usually request you for they tell you for a summons. They call you, they basically say the IRS. The assessment. They say they want you to do you want to see your 44 assessment. They send that to you. Whose document is it? It's their document. How do you have?
But you filled it out.
You didn't. You didn't fill out those documents. When they're asking you for government documents, it's the documents that they made up.
Okay, so the IRS is
And if they made up anything they give you is a document. And let's say the IRS guy's on the stand and he's going to prosecute you, and he's sitting there saying, "Hey, you know, a 1099, that's not yours. You didn't make a 1099 form. Somebody else made the 1099 form."
Yeah, but you filled it out. I don't get it.
You did not fill out the 1099 forms.
Oh, the 1099s. No, you didn't fill those out. But you fill out your tax return.
Your 1040 reform is not a tax. Well, it is a tax return. Yes, you're correct. But when is the 1040 tax supposed to be due?
And quarterly, depending.
No, when you're dead.
Okay, you need to explain that further.
A 1040 form is a tax on the estate. The only time your estate can be taxed is when you die. When you're dead.
Boy, you're opening up a can of worms here.
No, you're
anyway,
dead. You're dead. Then
Then it doesn't matter.
One of my friends held up his driver's license, said, "Hey, does this look like me? Is this me?" The guy goes, "Yeah, that's you. So I'm not dead, right?" "No." So then he quoted back the code that says that the 1040 tax, the 1041 tax is a tax on the decedent estate, which means you're dead. If I'm alive,
why is anybody paying any taxes?
Why is anybody? You have to pay the taxes that you lawfully owe. You have to figure out what your lawfully is that you owe.
Huh.
So, if it's a dead tax,
yeah.
See, so what is it? What is a tax court?
What is a tax court? It's I guess a court.
Debate the issues of your property and what you owe taxes on according to law.
No, the tax court is for evidence only. So when you put evidence into the tax court, like your own self-assessment, that you're still alive and haven't died, so therefore there is no taxable assessment, or you come up with whatever it is, what your taxable assessment is for that year. you do research on it. I can refer you to a book you can buy, and you can read stuff up at how they came up with a 271-page assessment on themselves. Then they entered their assessment into the tax court records. And then the IRS guy objected at the hearing.
Mhm.
And he says, "I'm sorry, sir, you don't understand this court. You cannot object to anything in this court. This court is not a court of law. This is a court of evidence. I am putting in my evidence or my report. It says I have to put in my evidence, or I have to file a tax return or a report. Here's my report." I'll go back. I can't say the guy's name, right?
Okay.
But we went to the IRS. He did the who's who. His house got raided by the who is it? Who came in there? Oh yeah, it was the United States Postal Service came into his house and raided his house. And he said the search warrant says you can't have that. What do you say when a child tells a child not to do it? What do? They take it, right?
Yeah.
So he said, "This is related to my divorce. You can't have it." They took it. "This is related to this. You cannot have it." They take it. So they took all the same. While they were taking everything out of his house, he was on the phone talking to the every county has what's called a report officer, right? Duty officer. So he called the duty officer of the court, right? And got a case number, gave him an incident number. So then he took the incident number, then called 911 and said, "Here's my incident number. I'm reporting them. These guys are stealing stuff out of my house, and your guy's helping with them. This is the guys. This is the police. This is the sheriff's name. The sheriff deputy helping them haul the stuff out. He's helping them. He's supposed to make sure they only take the stuff on the warrant. They can only take what's on the warrant, not anything else. If it's not on the warrant, they can't take it." So anyways, he reported that stuff. So needless to say is they took all his stuff. So he had to go to the IRS to go get copies of his stuff. So he figured they'd have copies. He could get copies, right?
Right.
I was with him physically at the IRS, talking with the agents, looking at the screen. It says, "You have my report." "Yes, your report was filed here, sir. We have it that you filed your report." "Uh-huh. Mm-hmm. Can I have a copy of it?" "No." "But you have it." "Yes." "Why can I not have a copy?" He says, "Sir, nobody in the IRS can the IRS no longer has control over your documents."
Huh.
He goes, "What do you mean the IRS? I gave it to the IRS." She goes, "Yes, ma'am, you're right, sir. You gave it to the IRS." But as I show, she turned the screen around. As you see here on the screen, sir, it says the NSA has your tax filings.
NSA?
We do not.
National-
So we could
the
not
National
get.
Security Agency.
National Security Agency had copies of his IRS report that he put in.
That's weird. Why the hell would they have it?
Because at the end of the report says, if you rule against me or if you do not decide in my favor, I reserve my right for a declaration of independence from the United States of America.
Huh. If they're a national security threat, because you want to do yourself
No, they wanted to make sure that they were nicely put away neatly somewhere else where nobody had access to, because they didn't want anybody else to copy his paperwork.
Boy, throwing.
Because it took it out of the IRS's hands and put it into the NSA's hands, and they kept it there.
That's messed up.
No, it was actually nice. He doesn't have any problems with the IRS.
Why does the NSA have an interest? I don't get it.
Because if he wants to file a Declaration of Independence against the United States, he would use a form to do that through them.
Oh, really?
But, that's only speculation. I just know that they have it. And he's never had a tax problem since. So I don't know. That was just the weird part. Okay. This was just weird. Okay.
Yeah.
These are all landmark cases.
They're all crazy stuff, crazy shit
It's
that's
amazing,
happened.
but it works. And that's why you're on
Well,
the show, because your you know, ways of going about it work
well, they're legal.
as
Well,
unconventional as they are. And
they
that's yeah.
have worked. Yes, I have. They have a great success rate.
Okay.
Oh, man.
At
Because
this point,
because I don't because I don't. There's certain things I don't do. I don't call what's patriot mythology and bullshit. That's what I say. Okay.
Okay.
There's a lot of that out there. Okay. If you
okay,
can't
at
find,
this point, I have to ask you, how much more do you want to go on the show?
I'm fine. I'll go further. I'll go longer. It's all right. I'm
Okay.
having fun.
You're
as long-
having fun. Fantastic.
As long as Angel's cool too, he's there holding his ship going. So I don't, if he's cool, I'm good for more too.
Okay. So you have to get the evidence into the record, right?
Mhm.
There's a famous IRS case. The guy, so you got the IRS agent on the stand, right?
Right.
And well, he owes the debt because it's 1040. Objection, Your Honor, it lacks foundation. Well, I'm telling you the foundation. It's a 1040 says this. 1040, I forget what they call it. What do you call it? Yeah, 1040 form says this. And objection, Your Honor, lacks foundation. No, I'm telling you what I see. It doesn't matter what you see, sir. You have not told us why the 1040 form has to be put into evidence. You have not stated why anybody has to file a 1040. What the statute is, it says that we have to file one. If we don't have to file one, it can't be used as evidence and you cannot testify about what it is.
Okay.
Now that's what the guy says. So basically they say that argument, right? Okay, now we're going to go back. We're going to go back to the case. It was a landmark case. This guy took a report from the IRS.
Right.
Found the IRS, found the report, and it said that the 1040 form was not legally allowed to be used by the Department of Management and Budget, did not authorize it as to be a form used. Right?
Okay.
So if the federal government doesn't allow you to use a form, how can you fricking ask for one? Anyways, sorry, I didn't mean to swear. Please forgive me, God. All right, now go on. So so basically this guy took the report, took it to the county clerk and recorder's office and filed it in the miscellaneous files. Some states have miscellaneous files. Other states do not want you to put stuff in the miscellaneous files. Depends on where you're at. Some poor states are more friendly to put stuff into the county miscellaneous file. Just giving an instant out there. Nevada is hard as hell to get anything filed in. But anyways, so the guy filed it, got a certified copy back, right?
All right.
So now it's certified by the county with a seal, bond, and stamp on it. So now it's authenticated evidence by the county. So now you take that authenticated evidence and you stick it into your court case, and now the IRS, the judge has to look at that report. Now that report can come in. Well, that's how he won. Because they were saying, file this. He says, Your Honor, how can they say the mandate that I file something that the Management, Tax, and Budget Office says it's not even an authorized form to use? If it's not an authorized form to use, I can't use it, can I, Your Honor?
Right. Does that mean I'm being swung on Robert, Your Honor?
So the judge dismissed the case.
Wow.
And that's the first time anybody's ever used the evidence code against the IRS.
Wow.
In that way.
And
the other magnificent attorney, he might be or might not be alive.
Okay.
Okay, I'm sorry. I'll do that later. Oh wait, there it is. I found it. This book is funny as hell. It made me laugh. How I Survived the IRS: My Battles Against Goliath by Michael Lewis Mipps, Minns.
All right.
He's also in the Guinness Book of World Records for the most law degrees, most bar association cards.
Wow.
I think it was 33.
Interesting number. Huh.
Yeah, he was a member. Maybe it was either 23 or 33. I can't remember. I was just laughing. But anyways, this is his case on Goliath. It was written, but he actually got fraud on the court by the guys.
Oh.
It was
That's
written.
right.
It was written in 2001. The one IRS agent took early retirement, and the other one was no longer allowed to do anything except enter stuff into the computer. He was taken out of the field.
Wow.
They should have been both fired and put in jail. But anyways,
Yeah.
But that case proved written perjury on the court, which was let's see if I can.
And check this out. What about making money defending?
Making what?
Money, $7,100. I want to ask you some questions. Can I order that $7,100 to the stand, Your Honor?
Oh yeah, money. They sue the money.
So yeah, they sue the money. That's
so
what Gary is. Gary's in a case.
So you have to argue that the money was lawfully under lawful means created.
What?
You had a lawful right to the money.
Oh yeah.
The money was formed in a.
Can I talk about that for a second? Can I talk about Gary's case? So with all these cases, not just Gary. So Gary was in a little tussle because.
Wait! You told me the one part, but I just got a question.
Yeah.
Is the case open?
Yeah.
Yeah. Yes and no. They're saying case closed, but no.
But they didn't sign the order.
Speaking of which, I just got the electronic filing now for what we just put in, so it's in.
Yeah.
Basically, you
well,
stick.
Just let me tell you. We put in a Rule 19, and then we just put in a Rule 12. Okay. Basically, Gary never accepted the jurisdiction of Admiralty Court, and that's why we wanted Rule 19. Okay, and so the judge is not answering. The judge didn't answer any of these motions for over 90 days, so we put in the Rule 12 motion saying that all your orders are no longer viable because you didn't work
The term of court in Colorado is 30 days.
Okay, explain that, please.
The term of court is when the judge says he's going to do an order and he has to write the order. It's 30 days.
Excuse me. Okay. Well, he did write an order. Okay. However, he didn't sign one of the orders. He didn't sign, and then we brought up an issue. Okay. So I don't know. You know, in Colorado, marijuana is legal, right? So
it's legal in the state and illegal in federal.
Right, and the feds came in. You know, the feds rated it. Yeah, they took it, but he plea bargained, and it was just that he grew too many plants. But they never tied what they took to the ruling.
No, they argue that the stuff have to answer the questions, the money.
Yeah, which is like ridiculous.
Well, I did. I showed that.
No, if it's a case against the money, does it have his name anywhere on the case?
Yes, that's a claimant. I was getting to that.
Okay.
All right. So it's like claimants really have no right. You just can come in and like, it's my money. And then they say, whoa, it's too late. You missed the deadline to claim your money. But Gary had asked for the money back when it was back before it went to the forfeiture court, back with the DEA. So he did ask. And when the DEA transferred the case to the forfeiture court, That all went with, and that all went with the papers that he asked for his money back. And then the lawyer saying, "Oh, he didn't ask for his money back timely in our court." And then I showed the law. Well, it doesn't matter because he asked for his money back when he was dealing with the DEA. Okay.
And they basically sent by paperwork they sent me. They said that I received, and it was because of the corona thing, the mail. No mail came to my house. The guy signed for it, not me.
Sure.
There's issues here, and there's basically it wasn't done right. Either way, it wasn't delivered to me. And they say, well, they said it's delivered. I said, well, nothing's handed to me. If it's certified, I got to sign for it. No one signed for
Well,
it.
if they issued an order that they took the money.
Yeah, they issued an order that Gary didn't ask for his money back
Okay.
Right.
fast enough, so therefore we're keeping the money.
Yeah, I need
Okay.
money.
So
back.
the first thing we did, or Gary did, was challenge the jurisdiction. He is not particular to Admiralty Court. Doesn't
Right.
matter what the court says. Okay. First of all,
Admiralty-
Colorado.
Admiralty Court is the only court that can do forfeiture.
Then why asking me to
No other court can do forfeiture.
All right, then case dismissed because his anything that was involved with Gary never touched the sea, never touched any transportation lanes. Okay, they can't be calling for Admiralty jurisdiction on what they took, his money.
Admiralty jurisdiction is overlaid over every state.
But the supremacy laws is the United States Constitution.
Well, here's the problem. Was it the state court that did the raid or the federal court did the raid?
State, El Paso County.
DEA, and with the help of El Paso County.
Okay, did they do it jointly?
I believe they were here with them.
Did they say joiner in the case between the two?
No, they never said.
Not
Never said.
no. Not
No.
I recall. No.
Okay, was a ticket that they handed you signed by both?
What ticket did you get, Gary?
I didn't get a ticket. They put cuffs on. That was my ticket to jail.
Okay,
But,
they put tickets on. Oh, they handcuffed you.
Yeah. There's stuff there about that's funky, but you know,
they impeded your liberty. They stopped your locomotion, which impeded your liberty.
Right, they did. They raided my house as a setup. I went to the gas station, and
How many agents were there?
how many? God, how many that came up on me?
No, how many were present and when they put the handcuffs on you? How many people?
I would say more than a dozen.
Okay, that's 15,000 each person.
And at my house, well, that would have been like 20, 30 people here.
So you have 30 times when that witnessed you in handcuffs.
Yes.
So 30 times 15,000.
I don't know what you're saying, sir, but hopefully we can talk privately afterwards.
No, let's hear it. Let's hear it now.
Basically, if any officer impedes your liberty and the other officers witness your impeding of liberty with the handcuffs being placed on you.
Yes.
Were you handed a warrant?
I wasn't handed a warrant. I was in cuffs for like 45 minutes before I went to my home, where they were already in my house. I guess to my wife, they showed me the warrant after the fact and a list of what they took.
No, that's not proper.
Well, that's what they did.
No, it's nice that they violate Rule 4.
And they smashed my
because
video.
Criminal rules, civil procedure, criminal rules of procedure, Rule 4 states that they have to have the warrant in their possession, signed by a judge on the authority of a person issuing the warrant before they put the handcuffs on you.
No, oh no, okay, I was kept in cuffs for 45 minutes. They dared me to run. I said no. I stood still for the whole time. Hey, it is what I'm not safety for everyone involved, right? And I just stood there, and when we finally went to the house 45 minutes later, I was in there at my house for like 10 minutes. They let the cuffs off so I could go feed my dogs while they were doing everything in my home already that they were already doing by the time we got there. They wanted to make sure they said that it was safe and everything in order for us to go there. And I said, yeah. And I was honest with them about every step of the thing, everything. And that's when the cuffs were taken off and then obviously put back on and then read my rights after the fact. Because I said, why do I have cuffs on me this whole time? If not even reading my rights, am I under arrest? No, you're detained. Then why do I have fucking cuffs on me?
No, you weren't detained. You were under arrest.
That's what he said. I was detained. Well, I don't know, man. But that's what he said.
Hang on. Here we go. I gotta look something up and read it to you. Hang on. It's
Can he reopen his case even after the judgment? Of course he can. If you got
there is a way to vacate a void judgment.
Well, I'm already halfway through the judgment of probation already, and yeah.
No, the probation part is gonna turn out to be unlawful arrest. No, treatise. I spelled treatise wrong. Dang it.
I know how to do that, sir. And there's no one here to help me do that. You know what I mean?
Yeah.
I have a template.
Well, I'm helping you with that, okay, Gary. But James is much better.
The treatise of.
Well, James, if you're willing to look, any type of, you said whatever, how many head a person. Look, sir, this ain't about the greed, it's the need. I need that money back. It wasn't all mine. It was my wife's too. But that being said.
Here we go.
It's a recompense for you to help. You said something about 13 a head. Let's count all the heads that we. I know there was at least 20, but I know there was more than a dozen.
Yeah. What percentage of the award will you give James?
He just said that seen me in handcuffs. He said, I believe seen handcuffs. Yes, they all have weapons. I'm not.
Awful.
Yeah. You said $15,000 penalty for each officer.
Yeah, that's what false arrest is.
False arrest.
You
so Gary
false imprisonment.
Yeah, Gary will gladly give you whatever percentage you want of the case.
Of course.
Hang on.
Well, this smells from the beginning, but those will be private talks on how all this even happened.
Yep. Okay. False imprisonment.
Yep, you'll talk to me about it, or yep, shut up.
Yes, I'll talk about it later.
All right, thank you. Respectively speaking, of course.
Yes.
But I mean, we're not wrong. I mean, Gary's not wrong to say I don't accept a jurisdiction of admiralty court. The supreme law of the land. The supreme law of the land is the constitutional law, and that's what.
Ask me. Why ask me if I don't have a choice? Why ask me if I give them permission? I say no. Then they never talk about it again, as if I didn't say anything. Then why ask me?
I understand that part. Right now, I'm just trying to find that one case here. False imprisonment is unlawful and totally restraint for the liberty of a person. The imprisonment is false in the sense of being unlawfully. The right violated by the tort is freedom of locomotion, which I thought was a really funny word. It belongs historically to the class of rights known as simple or primary rights. The theory of the law is that one interferes with the freedom of locomotion of another at his own peril.
Okay, so they basically did that.
There's plenty of witnesses. It was also at the cameras at the place where I was put in handcuffs at the gas station. So we have many witnesses, not just cops and people there with guns. Yeah, they put me in cuffs and dared me to run. I looked at them. I said, please. I mean, safety first for you guys, especially me. If this is my screw up, it is what it is. I'm not going to, threaten anyone's lives. You know what I mean? This my first offense. I'm not an effing criminal, everyone. Go F yourselves, okay? I'm not going to explain nothing to you. Many of you are sick. You're walking around putting butt plugs in your kids.
Okay.
All right.
We have a pasture on here. All right.
Well,
Yeah.
that's how.
Gary,
That's
shut your mouth.
on
All
our
right.
nation.
Yeah, I understand that part. But false imprisonment exists not only by words of action, but of fear of disregard, but also of such acts and measures that cannot be disregarded. No fear or disobedience needs to exist. If someone causes a situation that makes it impossible for another to exist, their liberty of or locomotion, it is a false imprisonment.
Well, then that's
So
what happened
technically, before they arrested you, the time that you were in handcuffs
for 45 minutes
is
before
false imprisonment.
Wow.
Well,
Because
that's
they're
great.
not. It's one or the other.
He's
So
got
it's-
to reopen the case.
I don't know how to. I cannot do that myself.
That don't worry.
All right.
Okay, so but
Okay.
again,
And then, you know what a wave just lifted off me when you said that? That's the spirit. It's got to be, man. It's got to be.
Yep.
When you
So
just said that, I just felt.
well, the important thing is that
Yep.
your record will go clean. Okay, that's the most important thing. Okay, but Gary needs his money back. Okay,
property.
yeah.
Okay, and we put in some good defenses anyway. The judge simply not answering any of our motions. All right, Rule 19 motion. What was that? Wasn't there what was it? Rule. They were functioning under Rule G, and then we came back and said, but what about Rule E? And what was the other one? Rule C and Rule E.
I don't know. There's so many, man.
Okay. And Rule C and Rule E took it out of the jurisdiction of Admiralty Court and put it into the hands and makes Gary a party under the federal rules of civil procedure. And that's what we were trying to do. And it's been how long? And the judge has not answered that.
You basically can do a removal back to the other court, but now it's too late to do a removal because it's past 30 days, but there's a way to do it. Hang on.
Well,
No, that's wrong.
Gary wants to charge interest on that money they took. And
Well, there is a already documented number of what it is. When they take it unlawfully or they take it,
yeah,
there's a figure number already.
Okay.
There is an interest number already calculated by the Supreme Court.
Okay, great. And then the second part is they took, biological material, I'll just say, from his house, and he wants that back, and it's worth $100,000. Hit the pot, okay?
Yep, you basically would end up with as a monetary damage against the officers, because see, you're suing the officers in their individual capacity, not the office itself.
Say it again, sir. You blipped out on me.
You would be suing the police officers in their individual capacity for stopping your locomotion.
Yeah, but for violating the law, because they were not.
That would be the DA agents and the sheriff's office agents.
It'd be the people that were there present.
The DEA, but they're two separate entities, or that matter?
Doesn't matter. You're suing the individuals, not the entities, not the governmental entities. The governmental entities can't be sued for that.
We're suing the guys that should have known better.
That's why they get sued.
Yeah, if they broke the law, then they can be sued in their individual.
I wasn't a threat. I wasn't running. They said I was just being.
They broke the law. They broke the law because they impeded his locomotion. Doesn't matter how long that locomotion was impeded.
Okay.
They impeded it.
Yeah.
And they did it before they showed him the warrant.
Right.
And so because it was done before they gave the warrant, it was not given in the manner, nor was the Miranda rights given in the manner and procedure the manner and procedure in which the Supreme Court says Miranda is supposed to be given.
Yeah, all right, and they didn't do that. So why is it okay for them to break the laws, lie about the evidence that they take?
Well,
And
that's what
You
James
got,
is
you know,
Stop.
you
gotta
got,
hold
you
them
got to,
accountable.
you go back to the Testaline brief.
But I
They
get
lied.
8 years.
They lied. Okay, for instance, the guy in California, they were going to sentence him to 10 years in prison.
Yeah.
Then it went 7 years. Then it went 5 years. Then it went 3 years. Then it went a year. Then it went 6 months. And then the last offer was probation. He said, hell no.
Okay.
So off the bat, if something's happening, you put in the constitutional question because that wipes out that problem. Now you have a problem because of time.
Is that what you would have to do in my case, sir? Is that a constitutional question? I mean,
There's a constitutional question there, but the problem is you use a constitutional question when you want to get all the way out and win altogether. The problem is,
all right.
the problem is that
If you lose, they'll throw a book at you.
they've already decided, they've already issued an order.
The probation based on a plea deal, right? Which does not associate.
The plea
taken. I want back.
What was the plea deal for?
Uh,
I'll rephrase that. Was it the state that issued the plea agreement or the federal government that issued the plea agreement?
I guess the state in the court I was in, the state, because I got the deal through my public defender. So obviously he talks to the prosecutor and yeah.
Yeah, he sold you down the river, but okay.
Of course, the weasel.
So anyway, so you got this here and they issued that. So it was the state.
Right.
Probably.
Yeah.
So now you just have to go after the
just the sheriffs?
Was it a federal misdemeanor?
It was
They call it a federal misdemeanor.
The original charge they said was a DF3 or a DF4, whatever that would give me 8 years. And then I pled down for just a degree lower and 5 years, no, yeah, 4 or 5 years on probation. I'm done with mostly all my recommendations, just a little community service stuff left. The fine, of course. What else? And it was down to, I think, a DF2 now or something. But either way, my property was never associated with any crime to the charge that I pled out to. Therefore, I should have my property back.
Okay, so that's the stance Gary took at the forfeiture court. There was never any relation, but the judge never answered on it.
Well, right.
And the
no standing. No standing.
And the state attorney never. I mean, what is she? She's a federal attorney.
Right.
Okay.
Right.
Never. You know.
Elizabeth Young. Yes.
Well, we have some things to talk about later, but basically, the federal question. If you're sued, the federal question gets things kicked out. Like they were going to sentence him to 10 years for the guns, but he ended up getting his guns back. Or the judge ordered him to give him his guns back, but he hasn't received the guns back yet.
Okay.
But so it's the plants. The plants were already destroyed. They burned them.
Right. And it was, there was nothing going on because my landlords tried to use that to throw me out. And that goes to another case, but we won't talk about now. But the thing is, there was no crime committed on my property. I could have grew it in Alaska. I could grow it down the block. It wasn't on my property, so they couldn't throw me out. So, and this is my home. I just rent the land. But there's a long story, all connected to another case in regards to a personal injury I'm going through. So they're desperate and, but regards to that, that's why I'm safe here because no crime was committed here. And yeah, I was Well, yeah, he said I was detained. That was exactly, no, you're not arrested, you're detained. Well, why do I have to have these cuffs on? You guys got machine guns there. You already
Well,
know
that's basically, it's either false arrest or false imprisonment. Well, one is they imprisoned you. They stopped you from moving. They impeded your, either way, they impeded your locomotive. You couldn't move.
slam me on the truck first, but that's okay. I guess their thing, right? I wasn't a threat, but either way, and I was, all right. I was in handcuffs. I was held against my will.
So there's remedy for you, but you might not get all of the remedy that you want, but you'll get a high portion of it.
All right, whatever that is, leave that to you.
I'll put it this
Gentlemen,
way: if they were to settle for a $15,000 judgment against each officer, right?
Right.
That $15,000 judgment can foreclose on their property.
Meaning I don't need to worry about my
It's
property.
going to get ugly. Anyway, gentlemen, I've got to step off because I got a major deal I'm working on. So
Okay.
I have to go. But if you guys want to continue talking,
So did you guys enjoy this?
oh, this is amazing.
Very
Uh,
much. I know.
I'd like
Listen, out there,
I'd like
will.
to create a debate next time with another lawyer from California who's another well-known legal advocate. His name is Gary Zerman, and he's been on our show. And I'm going to ask him to listen to this show and then make notes on what he wants to debate about what you said. I think it would make an interesting show. What do you think?
Okay.
Okay, and you'll like Gary. He's an amazing guy. So
Well,
Gary's
like Gary too, because this Gary needs help, and there's a lot going on. The why, that'll be a blessing. When you said that, though, I swear to God, man, I felt such a weight lifted off of me. It'll just lift off my chair, sir. And I'm not blowing smoke. It's a weird feeling.
Yeah, I know.
okay. Anyway,
I get that a lot.
I do feel this has been one of our best shows. So what we're going to do is we're going to go above and beyond our Call of Duty and really try to network this show out to the right places. And we're going to build up our listenership. And because anybody who starts listening to this show, they can't turn it off. It's just too riveting. And I bet you a lot of lawyers are going to listen to the show.
Especially as we make the show better. And again, that needs some help, but we're doing things despite that. But if any help, please send it to Angel Espino, and he'll tell out, how people could do that in order to help keep this show going. And because it's not about the greed, it's about the need. And I just don't have it like that. Maybe after, James here, who knows what this show could turn into. But, it's an important thing. And in the interest of justice, that's what all this is. And right or wrong, I was done wrong. My right should have still been afforded to me. Hopefully, okay. I'm explaining that right. But
okay.
Thanks, Frank. And James, when's a good time for us to talk so that's convenient for you?
Probably tomorrow evening.
So call you. You want me to call you tomorrow evening? Okay, sir. Thank you very much. Is there any final things?
Call me on that call, Gary, because I want to hear what goes on because it's interesting to me.
All right. So basically, no, I had fun. So I'll get you the website and the phone number, the email address and stuff to send stuff to you. If people want to talk or.
Now, your listeners, you're breaking in. Excuse me, right now. What do you want to leave them off with? What statement or words of wisdom and keep them coming back for more? You said you will be a return guest.
Yes, I will. It's just don't be down because the Lord is in the Word, and you'll find it, and you'll find the answer to your problems. Or whether you think hard enough or concentrate hard enough, the Holy Ghost will point you in a direction. There's always a remedy.
And look, he brought you to the show, and therefore, personally to me, that's weird. See, Frank, that's what I told you. That's how he communicates. You don't have to hear voices in your head. You read the circumstances. Hopefully, I'm explaining that right. But I'm still learning myself. I'm far from perfect. But thank you very much. And I'll call you tomorrow night, and we'll continue to rock, sir. And
all right.
Thank you very, very much, James. We really
You're
appreciate it, and also your patience to get you on the show. Okay.
So that was my problem. That was my problem with electronic stuff. I'm just going to say that.
Oh, we had our own here. We have our own going on. It's about commies doing some censoring and also needing some donations. to
Yeah,
help
we're gonna have a case against YouTube, and it's gonna turn class action. But that's another story. And we're gonna have the show follow it, and that's gonna bring a lot of listeners and a lot of people. We're gonna
Oh,
grow
it's
enormous-
just a
and
justice.
then we're gonna finally bring in some money and start paying everybody. And
Especially to Angel Espino there, PSN, Public Streaming Network. So, he's definitely, doing a lot to help make the show grow. And he has other people that he could be wasting his time with and affording. So, I'm not perfect, far from it. And he knows that. And he lets me know that too. And just one show at a time. He's tolerant. That's cool. I'm appreciative. And so are all of you, because without him, we wouldn't be able to be streaming this right now. It'll just be recordings. And I want to do a little beyond that. Okay. So thank you very much, James. I'll call you tomorrow. And you rock, sir. Definitely made our open up different think about different things, and you got a lot of people thinking, I'm sure of it. So thanks. And Frank, yes, I'll give you a shout. You can be in on that, I guess, no problem. And Angel, would you like to give a last word and how people can send donations to help this effort continue? Hopefully
thou shalt eat the bugs.
That didn't happen. That's what we're gonna stop. But
At
Angel,
angelespino.com, thou shalt eat the bugs.
all right. So, well, with that being said, I don't know, man. I'm feeling that fire again, and a good fire. And, but let's light one up under the asses of those who want to burn us with the fire and the bugs. Well, till next time, hopefully next week. You know me, but you really don't, because I'm being censored and suppressed, and they don't want you to think of anything else of me as being a terrorist. Yeah, we're all terrorists. Give me a break.
okay.
Good
night.
Bye.
Good night. Thank you.
Just talk and stop these steady voices. Just noises to me. I'm done, I'm through with your toxic world. I watch it burn to ashes. A silence, no regret. Let the fire rise inside me. I'm fire. All my life I've been waiting for a chance to burn it higher. Like me, I won't stop till I'll ignite. One punch, one shot will never break me again. Nothing you do can take me down. I'll never flinch, no fear. I'll never walk away.